Supreme Court of the United States and apply rules to its justices. The constitutional separation of powers means that no branch of the federal government can dictate how another should govern itself. That's black letter law. Now, why? This is to protect the people from abuse. The framers insulated the federal judiciary from political control to ensure that the justices would decide cases impartially, without fear of the kind of retaliation that fills the pages of some, not all, but some left of linen Democrats' playbook. Do my colleagues want the United States Supreme Court to tell Congress how to police itself? Even if Congress wrote a code of ethics for the Supreme Court, the court could rightly rule that code is unconstitutional. None of the laws we make here trump the United States Constitution. What's more, some Democrats want to use the lower courts as a cudgel against the highest court in the land by giving circuit judges the power to rule on whether justices should recuse themselves. Consider the conflicts of interest and the confusion that that would breed. Unless you peaked in high school, you must know they will be breathtaking. Now, the absence of an ethics code written by Congress in statute doesn't mean that justices lack guidance or accountability. Justices and judges routinely consult the existing code of conduct, and federal law already requires recusal in certain circumstances like bias or financial interest. We all know that. The justices are also subject to strict financial disclosure rules, just like my colleagues here. Not only is this Democratic proposal unconstitutional, it is unnecessary. The attacks on conservative justices are targeted. They're exaggerated. The alarmism is affected. The danger isn't that rogue justices are operating without ethics. It's that Democrats aren't winning every fight and they find that reality intolerable. I've been disappointed by Supreme Court opinions too. But my Democratic colleagues should fill out a hurt feelings report and move on for the sake of the Constitution. Look, the agenda-driven story here is that Justice Thomas has a rich friend who had no business before the United States Supreme Court. For context, let's recall that history is littered with examples of public officials failing to disclose their every transaction. We can acknowledge it's required by law. It is. We can acknowledge it's the right thing to do. It is. But we can do that without maligning each justice's motives and the entire institution's credibility, for God's sakes. You know who else amended their disclosures because of inadvertent admissions? Justice Ruth Bader Ginsburg, Justice Stephen Breyer, two good people. Justice Jackson made multiple amendments 3 days after President Biden nominated her. Not one senator brought that up during her confirmation hearings. Not one of my colleagues here walked into her hearings with the buckets of mud that they've thrown against Justice Thomas. Not one. Nor should we have. In the last month, some, not all, but some Democrats and their media allies have hyped up attempted hit pieces on every Republican-appointed Supreme Court justice except for one. They tried going after Justice Kavanaugh for buying baseball tickets, Justice Alito for having dinner with people who gossip, the wife of Chief Justice Roberts for hiring good lawyers, Justice Gorsuch for selling land in an LLC, which he properly disclosed to a major donor to the Democratic Party, for God's sakes, who's never even met, and Justice Thomas for having a rich friend. Justice Barrett, if you're listening, I hope you don't have library books overdue. If recent history is any indicator, you're next. Today's hearing is an excuse to sling more mud at an institution that some, not all, some Democrats don't like because they can't control it 100% of the time. And that's a fact, and everybody in this hearing room knows that. Until they get the outcome they want in every case, I fear they are going to continue to slander it in an effort to take control of it. And I pray to God I am wrong. Thank you, Mr. Chairman.
Thank you, Senator Kennedy. I will repeat what I've said before because I think it bears repeating. Violence against any public official, right or left, Democrat, Republican, or independent, is unacceptable. We have tried in this committee to pass legislation to make that point clear and enforceable under the law. When it comes to the Supreme Court justices and others, we have an obligation to protect them. And it was Attorney General Merrick Garland who has provided round-the-clock security for Supreme Court justices from the U.S. Marshals at their home, which I think is entirely proper. So there's no question about the bipartisan commitment to their safety. At this point, we'll introduce the three majority witnesses and turn it over to Senator Graham to introduce the minority witnesses. The Honorable Jeremy Fogel served as U.S. District Judge for the Northern District of California from 1998 until 2018. From 2011 to 2018, served as Director of the Federal Judicial Center, the research and education agency of the judicial branch, supports the efficient, effective administration of justice. Judge Fogel, served from 2004 to 2011 on the Judicial Conference Committee on Financial Disclosure. Before his confirmation to the federal bench, he was a state court judge in California. Kedrick Payne is the Vice President, General Counsel, and Senior Director of Ethics at Campaign Legal Center. Previously advised in Executive Branch Ethics Law as Deputy General Counsel at the U.S. Department of Energy, enforced legislative branch ethics laws and standards of conduct as a Deputy Chief Counsel at the Office of Congressional Ethics. Clerked on the Southern District of New York, practiced law at Cravath Swain, and I want to congratulate you on your brand new baby, 2 weeks old. I can imagine how difficult it is to pull yourself away from the family. We appreciate the fact that you're here. Professor Amanda Frost is the John Ewald Professor of Law at the University of Virginia School of Law. She writes and teaches in the fields of constitutional law, judicial ethics, and immigration. She authors the Academic Roundup column for the SCOTUS blog. Prior to entering academia, served on the U.S. Court of Appeals for the D.C. Circuit and worked as a litigator for Public Citizen. Now I'll turn to Senator Graham.
Thank you, Mr. Chairman. We have former Attorney General Michael Mukasey. Judge Mukasey served as Attorney General of the United States from November 2007 to January 2009, where he oversaw the Department of Justice and advised on critical issues of domestic and international law. Following his time as Attorney General, Judge Mukasey returned to private practice in New York, focusing primarily on internal investigations, independent board reviews, and corporate grievance. From 1988 to 2006, Judge Mukasey served as a district judge of the United States District Court for the Southern District of New York, becoming chief judge in 2000. From 1972 to 1976, he served as assistant U.S. attorney for the Southern District of New York, as chief of the Office of Corruption Unit from 1975 to 1976. He received his law degree from Yale in 1967 and his BA from Columbia College in 1963. Mr. Thomas Dupree is a partner at Gibson, Dunn, and Crutcher. Thomas Dupree is a partner, co-chairs the firm's nationwide appellate and constitutional law practice group. He is a seasoned litigator who has argued in all 13 circuits as well as U.S. Supreme Court. He's previously served as the Justice Department during the Bush administration. He served as Deputy Assistant Attorney General for the Civil Division and later became the Principal Deputy Assistant Attorney General. He was responsible for managing the government's most significant cases involving constitutional matters, perhaps virtually all of federal agencies, the White House, and senior federal officials. He has testified before Congress on constitutional matters numerous times. He is a graduate of the Williams College. He's graduated from Williams College and the University of Chicago Law School, where he served as editor at the University of Chicago Law Review. He clerked for Judge Jerry E. Smith at the U.S. Court of Appeals for the Fifth Circuit. Thank you.
Thanks, Senator Graham. After the witnesses are sworn in, they'll each have 5 minutes to make a presentation. Then members will have 5 minutes to ask. And I ask the witnesses to please stand and raise your right hand. You affirm the testimony you're about to give before this committee shall be the truth, the whole truth, and nothing but the truth, so help you God. Let the record reflect that all 5 witnesses have answered in the affirmative. The witnesses will be called in the order they're seated, and first will be Honorable Jeremy Fogel. Judge Fogel. Make sure you're.
Yeah, thank you. Got it. Thank you, Chair Durbin. Mr. Chairman, Ranking Member Graham, members of the committee. It's an honor to be here. Thank you for inviting me. I also want to acknowledge and say how honored I am to be here with my fellow witnesses. I think we all have something to contribute to this conversation. As Chair Durbin said, my name is Jeremy Fogel. I am a retired judge of the United States District Court for the Northern District of California. I served as a federal judge for 20 years and for 7 years as director of the Federal Judicial Center. Relevant to what we'll be discussing today, I worked very closely with the Judicial Conference and its committees when I was FJC director. My primary responsibilities were overseeing policy-related research and educational curriculum for the judicial branch, including judicial education about ethical standards and financial reporting requirements. The Chief Justice chaired our governing board. I had regular contact with him and with the circuit and district courts leadership, and I'm very pleased to say I have collegial relationships with judges all over the country of all judicial philosophies. It's something that's very meaningful to me. Before being appointed as director of the Federal Judicial Center, I was a member of the Judicial Conference Committee on Financial Disclosure for 7 years. I acquired substantial knowledge of the Ethics in Government Act and its application to judicial officers, including the redaction authority that's used to protect filers and their families. So the principal point of my testimony is that I think the court does need greater transparency in the way it engages with judicial ethics. And in this, I agree with Senator Graham. I want to be clear about why I'm here today. I am not here to question or criticize the conduct of any justice, and it's not my purpose to take sides in a political debate, which is an odd thing to say when one is in Congress, but it's truly where I'm coming from. I spent 40 years of my professional life avoiding partisanship. I treasure my relationships with judges across a broad range of political persuasions. And I have great respect for the court as an institution and for the justices with whom I've had the privilege of interacting in the course of my career. I'm particularly grateful to Chief Justice Roberts for his wide counsel and steady support during my time at the FJC. From a personal standpoint, given those relationships and given the respect I have for the judges and justices, I know it's awkward for me to be here. I do not doubt the sincerity of the submissions that the chief and the justices of the court have made to this committee. I think they are given in great sincerity. I think I'm here because I think more is needed. Over the decades, the court has been our most trusted government institution, far outpacing the legislative and executive branches in polls measuring public confidence. And that status has eroded significantly. Only a decade ago, 2/3 of Americans said they had confidence in the court, and now it's exactly opposite. About 2/3 say that they have little or no confidence in the court. And some of that erosion has had to do with controversy surrounding decisions. I think one would be naive not to say that. But there are also other factors at work. There's a persistently hyper-partisan political environment, an increasingly contentious confirmation process, the near disappearance of civics curriculum from our schools, and the pervasiveness of social media as a source of misinformation and disinformation about the law, the judicial process, and the judges and justices to whom that process is entrusted. In this fraught environment, I believe that the absence of a formal structure for defining and validating the ethical rules governing the Supreme Court justices is untenable. Too many Americans already think that the justices decide cases based on their political preferences and alliances rather than the law. Lack of clarity about the justice's ethical obligations only feeds that perception. Every other judicial officer in our country, whether state or federal, and regardless of the type of court in which they serve, is guided by explicit ethical standards and is subject to at least some degree of oversight to assure their compliance. The same is true for virtually all officials in the legislative and executive branches. While people familiar with the inner workings of the federal judiciary can read the court's submission to this committee and admire, as I do, the care and nuance with which it has been crafted, I fear that for everyone else, the processes and considerations that that submission details are a black box. How and when do the justices consult the court's sources described? What weight do those sources receive? Who, if anyone, not affiliated with the court is directly available to offer detached and independent judgment and advice? And most importantly, what procedures are in place to assure an appropriate degree of transparency that's consistent with the principles of decisional independence and judicial security. In his year-end report in 2011 and in his recent submission, the Chief Justice has explained how the Supreme Court differs from other federal courts and why it would be inappropriate for it simply to adopt the identical code of conduct applicable to all other federal judges. I agree with him about these points, but that doesn't mean that the court should have no formal code at all, that it couldn't adopt a modified code that accounts for these differences. For example, given the significantly greater impact of recusals on a court with only 9 members and no ability to draw upon potential replacements, the potential provisions of a modified code might identify and weigh factors for and against recusal differently. Because of its unique position in the judicial branch and the need to avoid a review procedure that might compromise its decisional independence or the security of its members, the court could designate a panel of retired judges with deep experience and unquestioned integrity to provide it with confidential advice as to whether an act, omission, or relationship raises an issue under the code. The point is that a formal code of conduct would provide clearly stated, visible rules and procedures to which the justices are expressly committed. Adoption of such a framework wouldn't make the controversies about the court or its decisions disappear, but it would be a statement to the American people that their faith in the court's adherence to core ethical principles matters. It also would reflect a recognition that given the outsized importance of their role, the justices should, in the words of former judge and noted conservative Michael Ludig, be bound by higher standards than other justices. Having seen firsthand the impressive ability of the court and the judicial conference to develop rules of procedure that have made our federal courts a model for other legal systems, both here and abroad, I have every confidence that such an effort would produce a carefully balanced framework of high quality and would represent a significant step forward. Thank you very much for the honor of appearing before this committee.
Thanks, Judge Fogel. General Judge Mukasey, welcome back to the Senate Judiciary Committee. Please proceed.
Thank you, Mr. Chairman. Mr. Chairman, Chairman Durbin, Ranking Member Graham, members of the committee, I thank you for inviting me to testify today and to share my thoughts on issues surrounding Supreme Court justices' ethics rules and their financial disclosures. I'm a retired partner and of counsel at the law firm of Debevoise and Plimpton. The views I express today are my own. They do not represent the views of the firm. I served as Attorney General under President George W. Bush from 2007 to 2009, and as a U.S. District Judge for the Southern District of New York from 1988 to 2006. I would like to deal today with 2 topics. One is policy principles relating to Supreme Court governance. The second relates to particular issues that have become current insofar as it's possible to determine the facts from publicly available information. As to policy, I believe that basic principles of the separation of powers mean that the court, as a separate branch of government and the only court specifically provided for in the Constitution, is solely responsible for its financial disclosure and ethics rules. Just as Congress establishes the rules that govern the conduct of its members, and just as conflict of interest statutes that apply generally to government employees do not apply to the president or the vice president. It's basic to the structure of our government that the executive, legislative, and judicial branches remain separate. It is the Supreme Court and not the Congress that has the constitutional prerogative to decide whether to adopt a formal code of conduct governing the individual justices. It should go without saying that if Congress cannot compel the court to adopt a formal code of conduct governing the individual justices, neither may Congress prescribe such a code itself. A law compelling the court to adopt such a code or purporting to impose one legislatively would violate the principle of separation of powers and would also be unworkable, inasmuch as there is no authority other than the justices themselves to apply such a code. I am told of proposals to delegate issues of recusal to individual justices, recusal of individual justices to a court employee or to a panel of retired judges. Here, my own experience as a judge may be instructive. Recusal decisions are fundamentally judicial decisions, and a judge is as much obligated not to recuse when recusal is not warranted as to recuse when recusal is warranted. This is especially compelling at the Supreme Court level because justices cannot be replaced by other judges as if the court were a professional baseball team calling up minor league players to fill gaps in the roster. That's not to say that there are no principles and practices that in reality, in life truth, govern the conduct of the justices. As Chief Justice Roberts wrote to the chair of this committee on April 25, there is a statement of ethics principles and practices to which every single one of the current justices have subscribed. And indeed, he attached that statement to his letter. That statement itself covers the sources judges use when analyzing ethical issues in general and discusses a variety of topics, including financial disclosure and recusal in particular. The statement is more than 2 single-spaced pages in length, and I would not burden the committee with a recitation of its terms or purport to summarize it. However, the statement notes that since 1991, Supreme Court justices have followed the substance of the Judicial Conference Committee on Financial Disclosure Regulations that govern lower court judges and filed the same annual financial disclosure reports as other federal judges. And by recent legislation signed by the president, those reports are public. The statement itself notes that the Judicial Conference Committee reviews information in these reports and requests additional information when appropriate. It also provides ongoing guidance, and in March, it provided additional clarification on the scope of, quote, personal hospitality exemption to the disclosure rules. That clarification provides an easy transition to particular issues that relate to Justice Thomas. And I base my discussion of those issues on information generally available to the public. Justice Thomas has said that he and Harlan Crow have been close friends for many years, over 25 years, that Mr. Crow is in the construction business, does not have matters before the court. There's one trivial exemption to the last point, which I mention only because it shows how far some critics have gone. It appears that in one case, a business with which Mr. Crow is affiliated opposed an application by its adversary for a writ of certiorari, and the writ was denied. Such applications are reviewed and summarized by a panel of clerks, not by the justices themselves. It takes 4 votes to grant certiorari, so that if Justice Thomas had recused himself in that case, the result would have been identical, denial of certiorari. Justice Thomas has said that when accepting travel and vacation invitations from Mr. Crow, he consulted others, including colleagues, on whether applicable rules applicable at the time, would prescribe, including those in his financial disclosure forms. He was advised that the personal hospitality exemption applied and that such accommodations need not be included. As the Chief Justice noted, the Judicial Conference Committee recently provided a clarification of that exemption that appears to confirm that the advice that Justice Thomas followed earlier was correct. And Justice Thomas has said that he will be guided by the new clarification and will include such travel and vacation accommodations in all future reports. In addition, Mr. Crow bought from Justice Thomas and his family 3 parcels of property in Savannah, Georgia. The Savannah parcels had included 2 rental properties, but those were torn down. Justice Thomas's mother, who was at least in her mid-80s at the time of the transaction, lives in the remaining house, which has been improved over the years and which did not have to be reported as a rental property because it was the justice's mother's home. She holds a lifetime occupancy right and lives in the property to this day. Mr. Crow has said that he purchased the childhood home of Justice Thomas with the intention to convert it into a museum of sorts to tell the story of Justice Thomas's life. The total for the parcels was $133,600, of which a third was Justice Thomas's share. That represented a capital loss to Justice Thomas. However, because the transaction was for more than $1,000, Justice Thomas was obligated to report it on his financial disclosure form, but did not do so because he mistakenly believed that he did not have to report a transaction in which he suffered a loss. He has said he intends to amend the financial disclosure form for the relevant period. It bears mention that Justice Thomas will not be the first justice to amend his financial disclosure forms. Justices Breyer and Ginsburg are among those who have done so without so much as the batting of an eye. and no doubt will not be the last. Recent criticism of Justice Gorsuch are also meritless. He said he sold an interest in a vacation home to a lawyer he had never met, who was a large contributor to Democrats, whose firm has litigated a dozen cases before the court, winning 8 and losing 4. The merits of these cases have not been discussed by these critics, nor have they indicated whether Justice Gorsuch wrote an opinion in any of them, cast a deciding vote, and if so, with what result. The lawyer in question says he did not know that Justice Gorsuch was the seller until an offer had been made. That's the story, period. Criticism has progressed, if that's the word, from meritless as to Justices Thomas and Gorsuch to ludicrous as to Justice Alito and others, with the claim that the Academy is exerting an improper conservative influence on the court by hosting conservative justices to teach or lecture. Apart from the history of similar invitations to liberal justices, anyone even slightly familiar with the current political climate at law schools, such that even Scalia Law School at George Mason University had to host Justice Alito by Zoom rather than in person due to security concerns. Anyone familiar with that history knows this claim is ridiculous on its face. The dark and intense criticism directed at justices over these transactions, the acceptance of trips and vacations from a wealthy close friend with no business before the court, pursuant to a since amended personal hospitality exception to the federal disclosure rules, and a property sale to the same friend at a loss, the arm's length sale of a vacation home, is impossible for me to square with the professed concern for the integrity of the court by those making the criticism. That integrity rests on the dedication of each justice to fulfill his or her oath by deciding cases on their merits, as the justices see those merits, even when they see them differently from one another. That integrity remains intact. If the public has a mistaken impression that the integrity of the court has been damaged, the fault for that lies for those who continue to level unfair criticism at the court and its justices. It's impossible to escape the conclusion that the public is being asked to hallucinate misconduct so as to undermine the authority of justices who issue rulings with which the critics disagree, and thus to undermine the authority of the rulings themselves. Thank you very much.
Thanks, Judge. Mr. Payne.
Thank you. Thank you for the opportunity to appear before you today. The purpose of my testimony is to explain how the ethical standards of the Supreme Court compared to the ethical standards of the executive and legislative branches of government. This matters because one way to understand whether ethical standards of the Supreme Court should be reformed is to first understand the ethical standards that already apply to other public officials across federal government. In particular, there are 4 basic ethics provisions that exist in the executive and legislative branches that do not exist in the Supreme Court. As a result, the Supreme Court has the lowest ethical standards in government. First, the Supreme Court does not have an internal ethics enforcement body. Without an internal ethics enforcement body, the court does not have one source responsible for providing ethics advice and for conducting ethics investigations. Justices rely on ethics advice from random and anonymous sources instead of in-house ethics experts. This leads to incorrect and inconsistent interpretations of the law. Also, investigations of misconduct are extremely rare, and when they do occur, they are conducted by court staff who do not have expertise in investigations or expertise in ethics. This leads to inadequate reviews of high-profile ethics matters. In contrast, the executive and legislative branches have ethics officials with sole responsibility of providing counsel and advice to officials and investigating misconduct. In Congress, both chambers have ethics committees that provide training to members and have the authority to investigate potential violations. In the executive branch, the Office of Government Ethics and designated ethics officials at each agency are able to provide training, counsel, and advice, while the Inspector General can investigate potential violations. Second, the Supreme Court does not have a binding code of conduct. Instead of a binding code of conduct, the Supreme Court has stated that it voluntarily follows the regulations of the Judicial Conference while emphasizing that the Judicial Conference does not have supervisory authority over the court. As a result, the court does not demonstrate a willingness to hold itself accountable for conflicts of interest or other ethics issues that are not currently codified in law. On the other hand, the executive and legislative branches have adopted codes of conduct and extensive rules that support public trust in government. Third, the Supreme Court does not have meaningful disclosure of privately sponsored travel. Because of the limited information that is disclosed with privately sponsored travel for justices, there's public criticism of potential conflicts of interest, especially based on the frequency of these trips and the recreational nature of these trips. Therefore, all privately sponsored travel by justices can fall under a cloud of suspicion even when it's legitimate. In comparison, the other branches have strong rules to address this issue. The executive branch heavily restricts officials from accepting such travel. And in Congress, there are extensive disclosure requirements required before and after members take trips with privately sponsored entities. This includes the cost of the trips, other attendees of the trips, and the agenda. This information allows the public to determine whether there are any potential conflicts of interest. And finally, the Supreme Court does not have a compliance procedure for its recusal requirements. The concern is that the court is without a procedure for informing the public the way a justice decides to recuse or decides not to recuse from a matter. As a result, the public is in the dark as to whether the justice is ignoring a conflict of interest or has a legitimate explanation for why no conflict of interest exists. In contrast, again, the executive branch procedure for determining whether recusals are required includes public disclosure of detailed ethics agreements between the ethics lawyers and the senior official to clarify what are the potential conflicts of interest and to have a path forward to eliminate such conflicts. In conclusion, there may be room to debate specific pieces of legislation that can reform the Supreme Court effectively, but there is no room to debate that the Supreme Court has the weakest ethics rules in federal government. Ethics rules in the executive and legislative branches can serve as models to improve Supreme Court ethical standards and increase public trust in the judiciary. Thank you for the opportunity to appear before you, and I look forward to your questions.
We will return to this hearing in just a few minutes. We're stepping away to keep our over
Chairman
40-year commitment to live gavel-to-gavel coverage of Congress. The House is coming in for what we believe will be a brief session this morning. No roll call votes are scheduled, and then back to the hearing.
and distinct. Ordering the justices to adopt a code of conduct defends the separation of powers. The bill intrudes upon the core function of a coordinate and co-equal branch of government. It is the Supreme Court, not the Congress, that has the prerogative under our constitutional structure to decide whether to adopt a code of conduct that governs themselves. As Chief Justice Roberts has written, courts require ample institutional independence, and the judiciary's power to manage its internal affairs insulates courts from inappropriate political influence and is crucial to preserving public trust in its work as a separate and co-equal branch of government. This bill, and in particular its provision directing the justices to draft a code of conduct, put it out for public notice and comment, and then adopt it, seems to be animated by an assumption that the Supreme Court of the United States is no different than the Department of Agriculture or any federal agency that can be commanded by Congress to engage in rulemaking. Suffice to say, that is not how the framers drew it up. The relationship the Constitution establishes between the Article I Congress and the Article III Supreme Court is one of co-equals. The judiciary is not an inferior branch. The bill offends the separation of power in other ways. It would compel speech by the justices by requiring them to post ethics-related information on the Supreme Court website. It would require them to publicly disclose internal rules and guidance from the counselor to the Chief Justice of the United States. And perhaps most ominously, the bill would require the court to establish procedures under which individuals may file complaints alleging that a justice of the Supreme Court has violated the code of conduct or any provision of federal law. They could also file complaints alleging that a justice has engaged in conduct on or off the bench, and apparently at any point in their lifetime, that the complainant believes may have, quote unquote, undermined the integrity of the Supreme Court of the United States. The complaints would then be referred to what the bill calls judicial investigation panels, composed of circuit court judges who would then sit in judgment of the accused justice. If one were to try to design a scheme that would undermine Americans' faith in the legitimacy and integrity of the Supreme Court, these judicial investigation panels would be an excellent start. Another bill, Senate Bill 325, entitled the Supreme Court Ethics Act, charts a similar troubling course. It would task the Judicial Conference of the United States with issuing a code of conduct governing Supreme Court justices. When he testified before Congress, Justice Kennedy described that very proposal as legally problematic and structurally unprecedented because it would empower the Judicial Conference, a group composed of district and circuit court judges, to make rules that Supreme Court justices have to follow. The bill would also create what it calls an Ethics Investigations Council charged with investigating Supreme Court justices, not just for violations of the code of conduct, but for any conduct alleged to be prejudicial to the ethical, effective, and expeditious administration of the business of the Supreme Court of the United States. Another bill, entitled the Supreme Court Code of Conduct Act, would similarly create a designated ethics officer who would process complaints that a Supreme Court justice has violated the code of conduct or federal law, or has done something that the complainant believes to have been prejudicial to the administration of justice. The designated officer would then be required to publish the complaints against justices on the Supreme Court's website. Just as with judicial investigation panels, these proposals for an Ethics Investigations Council or a designated ethics officer would damage and debase the institution by encouraging frivolous and politically motivated attacks on the court's integrity. If you don't like the outcomes of particular cases, well, attack the ethics of the justice with whom you disagree and force them to post your accusations on their website. Finally, let me close by noting the provisions in the bill, Senate Bill 359, concerning the recusal and disqualification procedures for Supreme Court justices. Adopting these measures would open the door to a tidal wave of disqualification motions in virtually every important case. Round one in all the big ticket constitutional cases would be litigation over which justices are even eligible to hear the case. Here, too, it is hard to imagine anything more corrosive to public faith in the Supreme Court than what would become routine volleys of motions alleging that various justices are ethically compromised and must recuse because they accepted a meal from someone distantly connected to a case. Allow me to close by saying that the provisions of the bill I have discussed today seem to be animated by a dark and distorted perception of our judicial branch, a perception that is fundamentally at odds with what I have seen in more than 20 years of practice in the Supreme Court and the federal courts of appeals. In my experience, speaking as someone who has argued in front of hundreds of federal judges throughout the country, the men and women on our federal bench are of the highest integrity. Even when I disagree with the outcome in a particular case, I have never doubted for a moment that these are judges who are striving to do their absolute God-given best to faithfully interpret the laws and the Constitution of our great nation. Thank you.
Thank you, Mr. Dupree. Professor Frost.
Chairman Durbin, Ranking Member Graham, and members of the committee. Thank you for inviting me to testify today. I'm a professor of law at the University of Virginia, and I specialize in constitutional law, judicial ethics, and the federal court system. My testimony today will focus on Congress's constitutional authority to regulate the ethical obligations of Supreme Court justices. But I will begin by making a point on which I know we all agree. As a constitutional matter, the Supreme Court must retain decisional independence, meaning that the justices can never be penalized for their votes in the cases before them. Meaning that the justices can never be penalized for their votes in the cases before them. Meaning that the justices can never be penalized for their votes in the cases before them. Meaning that the justices can never be penalized for their votes in the cases before them. Meaning that the justices can never be penalized for their votes in the cases before them. Meaning that the justices can never be penalized for their votes in the cases before them. Meaning that the justices can never be penalized for their votes in the cases before them. That very first Congress quickly enacted legislation to bring the court into existence and to establish its operations. And it did so in the Judiciary Act of 1789, which has special constitutional significance because it reflects the original understanding of the framers and their contemporaries. So that act regulated every aspect of the court's operation. It set the size of the court at 6, a quorum for the court at 4. It provided the court with a budget and authorized it to hire personnel. It even assigned the justices to serve on lower courts and ride circuit around the country to do so. And finally, and most relevant today to our conversation, they required the justices to take an oath of office, and it's almost identical to the oath the 9 today have taken, which is that they must treat rich and poor alike, and they must adjudicate cases faithfully and impartially. And just a few years after that act went into effect in 1792, Congress established the first recusal statute, which for 75 years has also applied to the justices. In other words, as this history lesson teaches, for over 230 years, and for as long as the Supreme Court has existed, Congress has regulated vital aspects of its operation, including its ethical obligations. That remains true today when this Congress controls the size of the court, the quorum, when and where it meets, et cetera. But most important to today's conversation, this Congress has enacted laws that regulate the Supreme Court's ethical obligations. The recusal statute, the Ethics in Government Act of 1978, and the Ethics Reform Act of 1989. All of these laws were enacted by members of Congress who also take an oath to uphold the Constitution. For hundreds of years, dozens of Congresses have thought such legislation is constitutionally proper. To claim that Congress lacks that authority is to ignore the Constitution's text and structure, as well as this longstanding practice. Nonetheless, the view of some seems to be that the Supreme Court justices should be accountable to no one. They cite as support for this remarkable proposition this vague principle of separation of powers. So the Constitution was carefully designed to ensure that no branch of government is entirely separate and independent from each other. That is the equally familiar constitutional principle of checks and balances. In fact, in the Federalist Papers, James Madison, in the same Federalist paper cited by Mr. Dupree, goes on to say that each branch of government must have partial control over the others. And that is because, quote, ambition must be made to counteract ambition, end quote. Some justices today are repeatedly violating the ethics laws that Congress applied directly to them. This misconduct requires congressional action to protect the court from itself. For all the reasons I've given, Congress has the constitutional authority to enact such legislation. I look forward to your questions.
Thank you, Professor Frost. Each member will have 5 minutes to ask, and I'd like to start with you, Professor Frost. It's been stated, I'll say as a preface, that the reason for this hearing is that so many of us are unhappy with the decisions of the Supreme Court. I might state again for the record that my concern about ethical standards at the court predate this hearing by many years. In fact, 11 years. The first letter that I authored, which was signed by several colleagues on the subject to the Supreme Court, was mailed on February 13th, 2012. The president at the time, Barack Obama. So I wasn't waiting for this situation or any court decision to be interested in this issue. I think it was timely then and still is today. The second thing is the argument that we're out to get certain justices because they don't rule as we wish. I would have to say during the course of the public inquiry involving Justice Thomas and others, I've heard virtually every justice named with some question as to their conduct and activity. Now, some will say they were harmless activities and shouldn't be, no one should be punished for them, and they certainly wouldn't meet any high ethical standards. But I would just add that those of us who are in public service and bound by ethical standards and codes of ethics are certainly used to this experience. Every year when we file our financial disclosure forms, in my case, my income tax returns, I'm bound to have questions from the press, and I hope most of them are considered innocent but legitimate inquiries of a person in public service. Professor Frost, a man who submitted a letter for the record today, Judge Ludig, said of the issues that are before us, I quote him, "In complete agreement on Congress's indisputable constitutional power to legislate ethical standards of conduct that would be binding as to the non-judicial conduct and activities of the Supreme Court." You've heard arguments otherwise. I think page 12 of your testimony, which goes into one of the first acts of Congress, the Judiciary Act, belies this argument that somehow the Supreme Court is at a level where Congress can't address it. Would you comment on that?
Yes, and I'll also just note that I have been called to testify on this issue since 2006 and been writing about it since 2005. So similarly to your point, this is not a new issue in response to recent decisions. So the separation of powers argument, I find confuses me because, of course, I think we all know from civics classes, separation of powers is, of course, a constitutional principle, which means that the branches should have some separate spheres of conduct and some separate roles in our Constitution. But checks and balances is equally important. And the role of the Congress is to establish the Supreme Court. It's not just permitted, it's required. The Supreme Court of the United States is constitutionally mandated under Article 3, but there is no detail about how it is to operate because that was left to the Congress of the United States under Article 1, Section 8, the Necessary and Proper Clause. And immediately Congress agreed to do that in the Judiciary Act of 1789, as it was required to do. The Congress sets the size of the Supreme Court. That is not in the hands of Chief Justice Roberts and his colleagues. Congress establishes the quorum requirement. That is not in the hands of Chief Justice Roberts and his colleagues. When this Congress passes a law that says that they must recuse themselves, the judges and justices of our federal judiciary, when there are certain conflicts of interest, the justices are not free to say that law doesn't apply to me. I'm going to sit on that case anyway. And so what is troubling is there is an implication in the recent statement of policy of ethics policies, as well as some previous statements by the court, that it doesn't think these laws bind it. And I find that very confusing in light of the text structure and long history of congressional administration of the courts.
Thank you. Judge McKaysey, I'd like for you to address one issue. It appears to me that in the early days of our republic, an oath had a different meaning than it does today in this respect. It is in the swearing in of members of Congress, for example, kind of a pro forma exercise. It would seem the words of an oath in the early days of the Republic were taken much more seriously, so that when the Congress set out the oath for members of the Supreme Court, every judge and justice, quote, solemnly swear or affirm I will administer justice without respect to persons and do equal right of the poor and to the rich, and I will faithfully and impartially discharge and perform all of the duties incumbent on me. Those words were written not by the court, but by the Congress, enacted by the Congress. Don't you think that raises a question as to whether or not there is clear authority for Congress to put together laws that are as specific as this oath of office?
Respectfully, no, I don't. Prescribing the oath, which I recall taking when I became a district judge, is one thing. Prescribing the way in which the court administers its business and the way in which a court applies rules internally is something else. Part of the problem here is that no rule determines its own application. It always takes somebody to apply it. And the way the court functions internally is a matter to be left to the court. In particular on recusal issues, the law that applies to recusal issues across the board for federal courts applies to Supreme Court justices as well. When their impartiality might reasonably be called into question, they're obligated to recuse themselves. That applies to district judges, it applies to circuit judges, it applies to Supreme Court justices. That is a law of general application throughout the judiciary. But when we're talking about internal administration in dealing with their practices and the way they administer their cases, I think that's an entirely different thing. So I recall taking the oath, but I don't think it means that Congress has the power to direct that the internal business of the Supreme Court be conducted in a particular way.
Thank you. Senator Graham.
Thank you, Mr. Chairman. Are all the witnesses aware of the fact that when Justice Roberts declined the invitation of Chairman Durbin, that his letter was signed by the entire court? Are all of you aware of that? Mr. Fogel, do you think that was a wise decision?
Thank you, Senator. I think I said in my statement that I respect it. I think it was sincere. I think the problem, and I think it's significant, and I will grant that it was signed by all 9 of the justices. That's
my point.
Yeah, but
I just want people to understand that the court as a whole has a
Right.
problem with this, whether they're right or wrong. I don't, that's, I guess,
I'm sorry, Senator. I just wanted to say
Sure.
one other thing, if it's all right.
sure.
I think it's significant that they all signed it. I think it doesn't suggest that that's all that all of them would do. This is it's a point about which they all reached
I
consensus.
sort of,
Yeah.
like you and Mr. Payne mentioned something sort of struck a nerve
Yeah.
with me. I'm not into micromanaging the court, Judge McKaysey, but when you look at what other branches do versus the court, Mr. Payne, you say it's pretty obvious they have a sort of a lower threshold, right?
That's correct.
Okay. So what I would urge the court to do is take this moment to instill more public confidence. I'm not going to vote for any of these bills, but I think we'd all be better off if they did that. And here's what I want to kind of explain to people. In 1998, Justice Ginsburg donated a signed copy of her decision in VMI case where you had to admit women to a state school. And it was auctioned off at a fundraiser supporting the National Organization of Women's Legal Defense Fund. Now, I didn't know that until this moment. Do you all agree that if Judge Alito signed the Dobbs decision and gave it to the Susan B. Anthony pro-life organization to raise money, all hell would break loose in this country? Do you agree with that, Ms. Forrest?
So would I agree that if there was a sale of a,
If
opinion as a
Judge
fundraiser?
Alito signed the Dobbs decision, autographs it, gave it to the SBA group to raise money, it'd be all hell would break loose.
Oh, yes, and I certainly would agree that would be a problem. And in fact, I think that's one of the reasons that Congress needs to play an active role today.
Why didn't all hell break loose in 1998?
I'm
When
not sure what
Justice
the reaction was.
Well, when Justice Ginsburg
Yeah.
signed a copy of the VMI decision for the National Organization of Women's Legal Defense Fund. Well, I think we all know the answer to that. Justice Ginsburg, one of the greatest people to serve on the court, received an award from the National Democratic Women's Club. Can you imagine what would happen if Justice Roberts received the award from a Republican women's club? I think we may read more about it. Justice Ginsburg was given a $1 million award by the Berggruen Institute, and this is annual philosophy and culture award for major achievements in advancing ideas that shape the world. Now, she didn't get the money personally, but they gave her $1 million to give to other people. Does anybody have a problem with that? Does everybody have a problem with that? Well, I'm going to assume silence means yes. The point we're trying to make here, I think, is that this effort to come after Justice Thomas is, I think, organized by the left. I think this moment where we could find common ground is being hijacked. I take Senator Durbin at his word. He's been concerned about this for a very, very long time. But the point is, the game has been played differently. And now we're in a moment where this court is under siege in multiple ways. And that is the problem I think most of us have. What are the lines to be drawn, and who's the referee? Does anybody know anything about the organization Demand Justice? Negative response for all members. Do you know where their money comes from? Negative response by all members. Are you aware that they spent over $1 million in ads pressuring Justice Breyer to resign? Nobody knew that, right? So if you're worried about dark money, I think that's a legitimate thing to be worried about. Let's worry about it across the board. And I guess my point, Mr. Chairman, is that the efforts by Senator Schumer to go to the court and threaten the court with its very existence, the efforts by people to intimidate justices, decide cases before the court, can't be ignored. And here's what I worry about the most. This is not about trying to upgrade the ability of the court to be more transparent. It's about an effort to destroy the legitimacy of this conservative court. So to the panel, if you have any ideas or recommendations about how the court could be more transparent, count me in. That makes perfect sense to me. But when you look at the history of the way things have happened with the court, when a liberal justice does something, the reaction in the American media is completely different. The New York Times article about George Mason admitted a lot of other schools who did the exact same thing. And I would say to Justice Alito, don't sign a copy of the Dobbs decision and give it to the SBA to raise money. You would not receive the same treatment if you did what Justice Ginsburg did.
Thank you, Senator Graham. Senator Whitehouse.
Thanks, Chairman. Professor Frost, you distinguish between the adjudicative and the administrative function within the judicial branch. That has constitutional relevance to our ability to legislate?
Yes, I think that's a very important distinction.
Because we have no business interfering in the court's decision-making on matters before it. But as to the administration of justice, we do have the authority to pass laws, correct?
Yes, the Constitution intended Congress to play that role over judicial administration and not
In
interfere with.
fact, Canon 4 of the Code of Conduct encourages judges to testify in legislative bodies regarding the administration of justice. And that would not be there if it were not appropriate for Congress to legislate regarding the administration of justice, would it?
Agreed.
Moreover, you mentioned the Ethics in Government Act, the Ethics Reform Act, and the recusal statute. Those are all laws passed by Congress,
Yes.
and they all apply to the court.
Yes.
Indeed, in some cases, using the word justices specifically, which is the term that applies to Supreme Court justices only, correct?
Yes.
And has the application of those statutes to the Supreme Court ever been challenged by the court itself in the years in which they've been in place, to your knowledge?
Not to my knowledge.
Judge Fogel, you were at the Judicial Conference for many years. You've had to have the role that the Judicial Conference was given by statute, by Congress, to administer these laws. In the context of administering these laws, particularly under the supervision of the Chief Justice, were you ever told that these laws were unconstitutional or that the Judicial Conference or the Financial Disclosure Committee should not enforce them?
No, Senator, the justices complied, as did all of the other federal justices, with the disclosure requirements, or at least they made an effort to.
And in fact, one of the rules, one of the part of the law is that if there is a financial disclosure violation, then the determination as to whether that violation was willful and is subject to civil penalties actually gets referred to the Attorney General for determination.
That's correct. What the committee does is it looks at the non-disclosure or the incomplete disclosure. It determines whether it's something that could be remedied. Usually the way the committee functions is remedial. They try to get the filer to comply with the disclosure requirements. But if there's a willful failure, then the committee has the authority to make that referral.
And it does so based on a determination that there's reasonable cause for someone to believe that this might have been a willful violation.
That's correct.
Then the willfulness determination gets made by the Attorney General.
That is correct. But I have to
There
say,
are civil fines that are potentially imposed if
Yes, sir.
Okay,
That's
go
correct.
ahead, finish what you
well,
wanted.
what I was going to say was that the committee tries very hard with the filer to make sure that every effort is made to get a proper filing. So
In fact, it's okay for a judge. In fact, it's even encouraged for judges and justices to bring concerns about financial disclosure to the committee for a confidential opinion, saying, here's what you got to do.
that's correct.
And Justice Thomas did not do that with respect to these filings.
I don't want to comment on Justice Thomas, but normally the committee is there to assist with questions like that.
So has the Judicial Conference, again, under the supervision of the Chief Justice of the United States, ever suggested that it was unconstitutional for Congress to require that these forms be filled out, that if there are omissions in the forms, that be referred to the Attorney General, and that a civil fine could be imposed on a justice for failure to file? Has
No,
that ever been raised in your
Not
conversations?
not to my knowledge, sir. No.
Well, that's, I think, a little bit telling. I appreciate that. Mr. Payne, are you familiar with the concept of regulatory capture,
Yes,
sometimes called agency capture?
yes,
Fairly considerable literature about it in administrative law and economics.
yes,
So I'll ask you a hypothetical. Let's just say hypothetically that there were an organized effort to capture, in the meaning of regulatory and agency capture, to capture the court in such a way that it was beholden to and ruled in favor of big special interests. That's the hypothetical. Here's the question. If that hypothetical were true, would any ethics concerns be raised by justices consorting with individuals or associating with groups involved in that capture scheme?
yes. In that hypothetical, there could be potential conflicts of interest if someone was engaged in trying to influence the court and members of the court were engaging in activities with them.
Thank you. My time has expired.
Thanks, Senator Whitehouse. Senator Grassley.
Thank you, Mr. Chairman. Thanks to the witnesses before us. The framers of the Constitution carefully crafted a system of checks and balances. While the Constitution purposefully insulated the federal judiciary from political control, it's important that Congress exercise constitutional duty of oversight. Judges are expected to comply with high standards of ethics and integrity, and it does appear there needs to be better oversight. I've been a longtime advocate for transparency and accountability because I believe the public's business should be public. I've been a strong proponent of government oversight and the duty of Congress to be good stewards of the taxpayers' dollars. I've endeavored to improve our government and promote greater responsibility at all levels. I've worked on bills to root out waste, fraud, and abuse, and to foster integrity and accountability, including in the federal judiciary. Unfortunately, Democrats and their left-wing dark money interest groups, as well as their allies in the liberal media, have engaged in a crusade to threaten, pack, and smear the courts. They've targeted specific judges and justices who aren't implementing a liberal agenda that they can't ram through Congress. The goal of these efforts is to cast doubts on certain judges and justices, all because the left is opposed to recent court rulings. That's what this hearing is all about, undermining the American people's trust in our judicial branch of government. Today's hearing is just one political theater to delegitimize our judicial system, particularly Supreme Court. Judicial decision-making must be based on law and sound jurisprudence. It must not be subject to the whims of public opinion and clamor. It must not result in threats and intimidation. As this relentless political battering of certain members of the judiciary who aren't doing the bidding of the liberal grand plan is coming at a tremendous cost. Our judges and justices face harassment and public intimidation in their private life, despite federal law, which prohibits picketing or parading at a judge's residence. Our justices and their families often endure organized protests outside their homes. Judges and justices and their families face real threats to their safety and security. Unfortunately, the whirlwind that Democrats threaten at the steps of the U.S. Supreme Court really has been released against our judiciary. So I'm going to ask Mr. Dupree and Judge McKaysey two separate questions. The first one is for Mr. Dupree. Federal judges are required by law and the Judicial Conference to comply with these disclosures and ethical guidelines. Can you please give us a brief overview of the constitutional framework in which these rules and guidance operates? And then for Judge McKaysey, this question: how is the Supreme Court different than the lower courts with respect to complying with these rules? Mr. Dupree.
Sure. Well, thank you for the question, Senator Grassley. There are, of course, a number of statutes that affect the information that Supreme Court justices must disclose, and also governs things such as recusal and disqualification. In some circumstances, the statutes act directly upon the justices themselves. I think in those cases, they would concern what I think all of us would consider non-core Article 3 duties. And that's why, as a constitutional matter, it would be permissible for Congress to directly regulate the judiciary in that respect. There are other statutes where what Congress has done is created the Judicial Conference, which sets effectively regulations for the majority of the federal judiciary, but is not directly controlling upon the Supreme Court. Nonetheless, the Supreme Court, really as an exercise of discretion, has agreed to follow and respect and comply with those types of guidelines. So I think that constitutionally speaking, that Congress, or excuse me, the Supreme Court would be regulated in two ways. One is through direct regulation when it concerns a non-core Article 3 activity, and the other would be in indirect regulation where Congress directly regulates the lower courts, but the Supreme Court justices voluntarily agree to abide by and comply with those requirements.
Judge McKaysey.
Well, I agree with Mr. Dupree's portrayal of the way the system works. As to the mechanics, I think that the rules of general application that apply to all courts are applied to judges and justices. And and as was pointed out before, it's sort of an iterative process. You file your report, you file your form, and they get back to you. Those who review the form and ask for for greater detail when necessary. And generally it's provided. I think the one feature that was alluded to before about the Attorney General making a determination of willfulness, I don't know that that's ever been litigated. And if it were ever litigated as to a Supreme Court justice, I believe it would be found to be unconstitutional. That is not anything that I believe has ever been tested, certainly not on the Supreme Court level.
Thanks, Senator Grassley. Senator Klobuchar.
Thank you very much, Mr. Chairman. I guess I'll start with you, Mr. Fogel. The Judicial Conference, I think, did the right thing by strengthening the disclosure requirements that apply to judicial officers, including the Supreme Court recently. But the Supreme Court justices are still not bound to the code of conduct, as we've been discussing, for United States judges. Unlike all other federal judges, the code requires that a judge uphold the integrity and independence of the judiciary and avoid impropriety and the appearance of impropriety. How is a formal enforceable code of conduct help to ensure that the rules are consistently applied for every other judge in the federal system?
Well, who was bound to that for 37 years, both as a state court judge and a federal judge, it really is your North Star. It's what you look at in terms of the values you want to uphold as a judge. And it's something that guides your conduct, and it also is something that the public can look to and say, this is what we expect of our judges.
And do you agree with Judge Ludwig, who was just quoted by Senator Durbin, who wrote the committee to say if the Supreme Court does not subject itself to the highest possible professional and ethical standards, it can depreciate its power?
Senator, I agree with that. I think that the Supreme Court, my hope is, the reason I came here today really is I hope that the court will adopt a formal code of conduct. I think it needs to be modified in some respects because the Supreme Court is different in a number of ways. But I think the absence of a formal code is an issue that I hope that they will address.
I appreciate that and your thoughtfulness. Ms. Frost, thank you. You mentioned the Judiciary Act of 1789. You mentioned the Ethics Reform Act of 1989. You mentioned the Ethics in Government Act of 1978 as reasons that, in fact, Congress has passed laws in the past based on the Constitution about the operations of the court. Is that right?
Yes, that's correct.
Okay, so I go over here to you, Mr. Dupree. I really wasn't planning on asking you questions until you dissed the Department of Agriculture. Because you said their court is not just like the Department of Agriculture. And I was looking up, it was set up by Abraham Lincoln in 1862, being a big ag state that we are, 100,000 employees, serves the people of this country. Yet that department, which basically has jurisdiction over what our farmers do for ranching and farming and counter-cyclical payments. I mean, they've got ethical laws in place. So I actually see the opposite when I think about the power of this court. And I think about what Ms. Frost said. I think there is every reason that this court should have ethical rules like the fine Department of Agriculture, and that we don't look at that as a bad thing. We look at it as a good thing.
And certainly, to be clear on the record, Senator, no disrespect to the Department of Agriculture,
you
which
did
is
it.
a hallowed,
You did it,
hallowed
sir.
department and
You
agency.
decided
So-
that was the department you were going to mention.
Right.
And I think a lot of people in the middle of the country noticed it, but go ahead.
Understood. Again, no disrespect. My point with regard to the Department of Agriculture was simply that the provision of the bill, and several bills have similar types of provisions where they basically order the Supreme Court to engage in essentially a rulemaking function. In other words, to promulgate for public notice and comment a code of conduct. Again, analogous to what this Congress would say with regard to either the Department of Agriculture, Department of Defense, Department of Homeland Security, you name it. And my point was simply that as a matter of our constitutional structure, the Supreme Court is differently situated in a profound and fundamental way from Article 2 executive branch agencies, which can be vested with rulemaking power under the Constitution.
Thank you.
Article 3 can't.
Ms. Frost, you want to reply? Because this gets to the core of this question of us actually being able to pass a law and do anything.
Yes, I mean, this is the point about Article 3 of the Constitution. It's very short. It requires that there be a U.S. Supreme Court, has a few other provisions, but it leaves to Congress that essential role of administering the court, and Congress has always done so. So to question that authority today is to question 230 years of consistent practice where Congress has legislated regarding the court. To be clear, not to control its decisions, that is clearly off limits. But every other aspect of the court is controlled by Congress, from its size to when it meets.
Agree. Mr. Payne, why is it important that the Supreme Court also have an ethics office separate from the individual justices to provide them with advice on how to comply with the ethical obligations and to ensure that this office has the authority to conduct independent fact-finding?
The only way that any current ethics rules or future ethics rules will work is if there's a way to enforce these rules and a way for the Supreme Court justices to understand how they apply. So therefore, you need an internal body that can provide the ethics expert advice and also gather facts in the circumstances where there are potential violations that need to be resolved.
Ms. Frost, what do you think on that?
Yes, I would agree with Mr. Payne's analysis there. And I think that one of the problems we've been having today is that so many of these issues get dug up by investigative journalists and splashed across the news in ways that does damage to the court. If they had a more systematic method of adopting or approaching these problems, we could avoid this.
And Mr. Fogel, how would you handle that? Because you've been, trying to thread the needle here.
No, I am trying to thread the needle. I think the court's independence is very important. I agree with other witnesses who've said that. I think there are ways they could do better at getting independent and impartial advice about ethical questions. They don't really have, it's kind of a black box. As I said in my written testimony, they have a lot of sources and rules that they follow, but no one really knows what they are. And I think if they had a internal resource, I suggested, and I'm not alone in suggesting that they get a group of very experienced retired judges whose integrity is unquestioned. And I stress retired judges because then they're not subject to the problem that a circuit judge would have or a district judge would have, to just say, look, I have a question here. I'd like your advice. I mean, what do you think? Somebody who's independent, who doesn't have any skin in the game and can just say, yeah, I think this is okay, or I don't think that's okay. I think that's a modest step that the court could take.
Okay, well, thank you. And Mr. Mukasey, I'm sure we can talk about this in the future as my colleagues await, but you and I have worked together well, including when you were Attorney General. So
We have.
thank you.
Thank you very much.
Senator Cornyn.
I'd like to go to the video, please.
Committee will please come to order. Judge, it's a tough day and tough night for you, I know. Let me ask, do you have anything you'd like to say before we begin? And I understand that your preference is, which is totally and completely understandable, that we go 1 hour tonight, 30 minutes on each side. Am I correct in that?
That's right.
Do you have anything you'd like to say?
Senator, I would like to start by saying unequivocally, uncategorically, that I deny each and every single allegation against me today that suggested in any way that I had conversations of a sexual nature or about pornographic material with Anita Hill, that I ever attempted to date her, that I ever had any personal sexual interest in her, or that I in any way ever harassed her. A second, and I think more important point, I think that this today is a travesty. I think that it is disgusting. I think that this hearing should never occur in America. This is a case in which this sleaze, this dirt, was searched for by staffers of members of this committee, was then leaked to the media, and this committee and this body validated it and displayed it at prime time over our entire nation. How would any member on this committee, any person in this room, or any person in this country would like sleaze said about him or her in this fashion? or this dirt dredged up and this gossip and these lies displayed in this manner? How would any person like it? The Supreme Court is not worth it. No job is worth it. I'm not here for that. I'm here for my name, my family, my life, and my integrity. I think something is dreadfully wrong with this country when any person in this free country would be subjected to this. This is not a closed room. There was an FBI investigation. This is not an opportunity to talk about difficult matters privately or in a closed environment. This is a circus. It's a national disgrace. And from my standpoint, as a Black American, as far as I'm concerned, it is a high-tech lynching.
Senator
That
has a
was
minute and a half
32
remaining.
years ago. And I'm reminded as I get older that not everybody's had the same experience or memories that I have. That was one of the searing memories that I've had about Supreme Court confirmation hearings. And I think provides an important context for today's hearing. The truth is that, as Senator Kennedy said, starting perhaps with the Bork nomination, that members of the United States Supreme Court, when they've been nominated for the job, have been subjected to relentless campaigns of harassment and intimidation, which, as Justice Alito recently pointed out, can lead not just to intemperate attacks like the Senate Majority Leader made against Senator Gorsuch and Judge Gorsuch and Judge Kavanaugh by name back in 2020. It could lead unstable individuals to decide that they are going to conduct an assassination of these members of the Supreme Court. So things have gotten terribly out of hand. Judge McCasey, you and Mr. Dupree both talked about the separation of powers. I looked back at the rules of the United States Senate, our ethics rules by which we are governed. And they are rules that are set by the Senate itself. How do you think the Senate would react if the United States Supreme Court said, we don't like the ethics code of senators or members of the House of Representatives? Would the same principle of separation of powers and co-equal branches of government apply in that circumstance?
Yes, of course it would, Senator. This body sets the rules for its conduct, and the same way that the court sets the rules for its conduct, and the executive, in the person of the president and the vice president, set the rules for theirs. That's not to say that laws of general application don't apply. Of course they apply. But when you're talking about the particular rules relating to a particular branch of government, those are set by that branch of government.
Mr. Dupree?
I agree with Judge Mukasey, and I would add, Senator, in response to your question about the importance of the separation of powers, I think it's important to underscore that the separation of powers is not some sort of academic concept that was invented by law professors. This is a concept that is structurally baked into our Constitution, and the framers viewed as absolutely crucial to preserving not just the independence of each branch and ensuring that the judiciary could act independently, but also to preserve freedom and individual liberty. And so the things we're discussing today obviously have practical consequence in terms of granular information about data and disclosure and the like. But at the end of the day, what's really on the table is a concept that is absolutely fundamental to our constitutional structure and must be preserved.
I think Justice Scalia pointed out, among others,
Senator's
that
time has expired minutes ago. Senator Lee.
Thank you, Mr. Chairman, and thanks to each of you for being here. As we heard quoted moments ago, when Justice Thomas was in this room, in front of this committee nearly 32 years ago. He had some observations about his confirmation proceedings. And he described those proceedings as, quote, high-tech lynching for uppity blacks who in any way deign to think for themselves, to do for themselves, to have different ideas. He then described the consequences for doing those things. Quote, you'll be lynched, destroyed, caricatured by a committee of the U.S. Senate rather than hung from a tree. Now, more than 3 decades later, that observation remains tragically relevant. Today's hearing and the radical left's continued attacks on Justice Thomas and his wife, Ginny, over the last 31 and a half years are part of a sustained, hateful attempt to discredit an honest man and a principled jurist. The left, you see, can't tolerate, it cannot accept the fact that one of our greatest American success stories, that of a humble citizen who rose from poverty in the segregated South to become not only one of the Supreme Court's longest serving justices, but also one of the most influential jurists our country has ever known, is the story of a black man who happens to be conservative. Now, those leading the charge against Justice Thomas would have us believe that he simply couldn't think for himself, that he can't think for himself. And so his wife and his white friends must tell him what to think. And the truth is, the left simply disagrees with his decisions and with the decisions of our current Supreme Court. And they obviously can't persuade the American people to adopt their radical policies through legislation, so they're attempting to destroy the court's credibility and intimidate the Republican-appointed justices and their families, starting with Justice Thomas. They're making clear that justices who disagree with them will pay a price. And it's a price that the radical left is determined to ensure is very high. This is all just a thuggish shakedown. Nice Supreme Court you've got there, America. Sure would be a shame if something happened to it. And don't just take my word for it. Remember what Senator Chuck Schumer did in 2020, went onto the steps of the Supreme Court, called out specific Supreme Court justices by name, referring to Justices Gorsuch and Kavanaugh by name, telling them, you've released the whirlwind and you will pay the price. You won't know what hit you if you move forward with these awful decisions. Then in August of 2019, 5 Democratic senators, including 4 members of this committee, submitted an amicus brief to the Supreme Court of the United States. An amicus brief in which it leveled a threat, saying, change according to what we demand, or else the court is going to have to be, quote, restructured in order to reduce the influence of politics. Since the leak of the Dobbs draft opinion 1 year ago today, the justices and their families have endured constant protests at their homes, their churches, even their children's schools. There was even an assassination attempt against Justice Kavanaugh. And of course, when I say the justices in this context, I don't mean all of them. I mean the Dobbs majority justices, as only the dissenters in that case have been spared the rage machine's bullying, threats, and intimidation tactics. As Justice Alito recently observed in his comments to the Wall Street Journal, it was the Dobbs leak that made Justice Alito and those of his colleagues who joined in his opinion likely targets of assassination. As Justice Alito explained, quote, it was rational for people to believe that they might be able to stop the decision in Dobbs by killing one of us. Astoundingly, with that conversation fresh in our minds, Democratic senators are now threatening to defund the Supreme Court's requested police protection of the justices and their families unless they adopt specific measures that those senators demand. All these tactics, of course, are meant to harass and intimidate the court, specifically the justices appointed to the court by Republican presidents, and force them to impose the left's radical policy agenda on the American people, not through the legislative process, but by judicial fiat. The left has carefully coordinated these attacks with an increasingly compliant left-wing media. If you read articles from sources like the New York Times, Politico, and outlets like ProPublica. You'd think that the Supreme Court justices appointed by Republican presidents are universally reckless and corrupt, and those nominated by Democrats universally conscientious and virtuous. That bias becomes apparent both in what receives coverage and in what doesn't. One justice appointed by a Democratic president failed to recuse when her husband's law firm had cases before the court. One failed to disclose the sources of her spouse's income. One traveled for free with wealthy friends, including stays at the homes of prominent attorneys whose firms have cases before the Supreme Court. You wouldn't hear any of that from the biased media or congressional Democrats who conveniently point only to Republican appointed justices when demanding their reforms to the court. Now, I raise these examples not to accuse the court of being systemically corrupt or broken in any way. No, it's neither of those things. Let me just finish my statement if I could. I raise these things only to point out that Senate Democrats, left-wing advocates, and activists and their publicity outposts in America's mainstream media establishment never tell the complete story about this. And by telling only half the story, they reveal their true purpose, which is not to tell the truth, but to punish their political enemies. We cannot afford to delegitimize and denigrate the court in this way. It must stop. Thank you, Mr. Chairman.
Thank you, Senator Lee. We passed the Daniel Anderl Judicial Security and Privacy Act in the last Congress after the murder of Judge Esther Salas' son at their home. That bill was held up on the Senate floor for nearly a year by a member of the other party. Senator Coons.
Thank you, Chairman Durbin. The American people need to have confidence that government officials in all three branches are serving the public interest, not their personal interests. And the Supreme Court, as I think this hearing has demonstrated, suffers today from a lack of transparency and accountability when it comes to ethics practices. This is true for justices appointed by presidents of both parties. This is not a Democrat or Republican issue. This is an issue of transparency, accountability, and confidence. Last year, I led the successful passage of the Courthouse Ethics and Transparency Act, joined by Senator Cornyn, many Republicans. It was actually adopted unanimously. It's simple. It requires federal judges, including on the Supreme Court, to promptly report when they sell securities so the public is made aware of any potential conflict due to a financial interest. Members of Congress have had to comply with the same requirements, so we made sure that federal judges, all federal judges, should have to play by similar rules. Still, the Supreme Court is today subject to weaker ethical obligations than other branches of our government. I want to explore some of those differences briefly now. Mr. Payne, if I might, one obvious difference between Congress and the Supreme Court is the court has no formal mechanism to provide guidance, investigate allegations, or enforce ethical constraints on the justices. I'm the chair of the Senate Ethics Committee and have seen firsthand the value of similar structures. Why has the court failed to create a similar ethics body? And could it do so at any moment if it chose to?
It is unclear why the court has decided not to establish such an internal body. It is just a basic principle with any rules to have an enforcement or compliance mechanism internally. And they could create this immediately. All they need is to establish an office within the Supreme Court that has ethics experts who are professionals who can provide advice on the existing rules and can handle any new rules that are enacted.
If one were seeking ethics guidance as a member of the executive branch, legislative branch, judicial branch, and you simply turn to your colleagues rather than a professional office that was responsible for providing uniform and impartial advice, would you be practicing at the highest level in terms of your compliance with ethics rules
No.
and regulations? No.
No. If you rely on colleagues or anyone who is not providing guidance across the board, the advice will not be consistent and won't necessarily be correct.
In his response to this committee, to the letter from the chairman, Chief Justice Roberts noted the Supreme Court adopted a resolution in 1991 to comply with the Judicial Conference's financial disclosure regulations. But the court has declined to adopt a similar resolution that would bind the justices to the Judicial Conference's code of conduct.
Why has the court agreed to comply with the conference's disclosure rules, but not its broader ethics rules? And could the justices easily bind themselves to the code of conduct if they so chose?
It, again, is unclear why the justices decided to only bind themselves with the regulations. However, I point out that the Ethics in Government Act applies to the justices, so they really don't have the option to opt out. But they could easily establish a code of conduct for themselves to have rules that are applicable to them and can be enforced.
And is there any significant distinction among the other members of the Article 3 federal judiciary in terms of their report requirements, their disclosure, and their ability to have their conduct reviewed by an independent and impartial enforcement body? Is there any variation among the rest of the Article 3 judiciary?
Yes, unlike the Supreme Court, all of the lower court judges are bound by the same financial disclosure requirements, but they do have the judicial conference that can provide ethics advice that is available online, even in advisory opinions, such that it is clear what the rules are, how they apply, and what happens if there's noncompliance.
Last question, if I might, Professor Frost, Ms. Frost. Chief Justice Roberts has said it would be inappropriate for the Judicial Conference to supervise the Supreme Court. At the same time, he suggested he believes the court can't be constrained by Congress. That concept's been raised here today as well. In that view, only the court itself would be able to enforce its own ethics requirements. Do I understand that correctly?
Yes, that seems to be the position.
And it seems to me that's the equivalent of saying that they alone should be able to grade their own homework. I think Congress can legislate here if necessary. It may not be the most desirable outcome, but it is possible. In fact, I think we passed the Courthouse Ethics and Transparency Act by voice vote last year. Colleagues on both sides of the aisle co-sponsored this bill. Can you explain how we can reconcile this kind of legislation with the key principle of separation of powers?
Yes, that's because we're not talking about interfering with the court's decisional independence. We're not talking about penalizing justices for their votes in any cases. We're talking about the checks and balances that exist for all three branches, where Congress plays a role in establishing the administration of the courts. The Constitution requires that. And as part and parcel of that, establishes ethical guidelines.
In fact, I'd argue, Mr. Chairman, in closing, that if the most senior members of the executive branch and the legislative branch and the judicial branch are all subject to disclosure and reporting and compliance and enforcement obligations, for just one court of 9 justices to exempt themselves puts us at real risk of the highest court having the lowest ethical standards of the entire senior members of all 3 branches. Thank you, Mr. Chairman.
Thanks, Senator Coons. Senator Kennedy.
Thank you, Mr. Chairman, and thanks to all of our witnesses who have joined us today. Mr. Payne, let me start with you, sir. You're kind of in the middle here. You work for the Campaign Legal Center, is that right?
That's correct.
Is your website campaignlegal.org?
Correct.
Okay. Does not the front page of your website say, I'm going to quote here, I want to get it right, the current U.S. Supreme Court is a threat to our democracy? The current U.S. Supreme Court is a threat to our democracy. Did I read that right?
What I can say is that our organization.
But is that on your website?
I am not certain exactly what's on the website.
Here it is, right here,
Okay.
big as Dallas.
What that refers to is the voting rights legislation, voting rights cases of the Supreme Court. Our organization is a voting rights organization that fights for all Americans to have the ability to vote.
Yeah, but you got to click a bunch of times to find that explanation. I just want to make sure I read that correctly. A few months ago, Mr. Payne, you retweeted the following statement. Some justices are politicians in robes who thrive in a system where access and influence are for sale. Some justices are politicians in robes who thrive in a system where access and influence are for sale. Now, that's a pretty bold statement.
I'm sorry, Senator, is that a news article?
No, sir, that's a retweet here. You tweeted this out. Tell me which justices are for sale.
I don't recall that tweet, but
Here it is. November 21, 2022. Can you tell me which justices are for sale?
no.
Are any of them for sale?
No, the problem is that the American public has a perception that some
Yeah, but
justices
I'm
may
gonna
be.
establish the point first. I want to know, you tweeted this out. Do you believe that some justices are for sale? And if so, which ones?
No, Senator, I do not believe that justices are for
Then why'd you
sale.
tweet this out?
What, can you provide more context of what
Sure,
that is? that
I'll get you a copy, but here it is. I
Okay.
checked it and triple checked it. You also said less than a month ago that John Roberts, you retweeted this out. John Roberts is a disgrace.
No, I actually,
Not I disagree with Justice Roberts. Well, you didn't call him Chief Justice Roberts. You called him John Roberts.
no, this is,
Or
that's,
you
that's,
you retweeted this.
no, Senator, I did not retweet that.
Yes, sir, you did, right here.
I will
It's
need
big
to
as
see,
Dallas.
I will, can you provide a copy to me
Sure,
now? But
sure.
I did not retweet.
Can you tell me why you think Chief Justice Roberts is a disgrace?
I did not say that, did not retweet that.
Oh, okay. Maybe Twitter got it wrong.
Someone got it wrong.
Let me ask you this, because the unstated premise of all this, sometimes it's stated, but the unstated premise of all this is that some justices have been bribed. Let's just cut to the chase. Okay? Now, let me stay with you, Mr. Payne. Well, let me go to Mr. Fogel. I don't want to just pick on you, Mr. Payne. You can be looking up on Twitter where you said those things. On April 4th, 2019, the American Civil Liberties Union paid for Justice Sotomayor's trip to San Juan, Puerto Rico. You ever been to San Juan, Mr. Fogel? Is it expensive?
I keep forgetting. Well, it depends when you go.
Yeah. How much you think it costs to go down there?
Depends whether you fly first class or economy.
What if you fly first class?
Oh, probably a couple $1,000s.
Okay.
Yeah,
The ACLU, do they have cases in front of the Supreme Court?
all the time.
They do, all the time?
Sure.
Do you think the ACLU was trying to bribe Justice Sotomayor?
No, sir, I don't.
I don't either. I don't either. But that's the unstated premise of all of this.
Well, Senator, if I
All
may,
these articles about Justice Clarence Thomas and the Chief Justice in the United States and Justice Gorsuch, who sold an interest in an LLC to a Democratic donor who had never met, that they bought him, isn't it?
may I say something in
Of
response,
course.
Senator? I think there are two things going on here today. I think there is a political conflict, which is, as I said earlier, it's very intense. It's hyper-partisan. Both sides have things to say. And then I think there's an ethical
Well,
issue.
when you accuse people of being bribed, it kind of
No, I'm not
it kind of
accusing.
gets their attention.
Sir, hold on a second. I'm not accusing anybody of being bribed. I'm not.
But some people are.
Some people are. The reason I'm here is I think that there is an ethical issue that, as Senator Graham said earlier, it would be good for the court to think about in terms of being more transparent. That is what I care about. That's the only thing I care about. There's a lot of political back and forth. It's very interesting. I'm very interested in it as a citizen of the United States. But I think the most useful thing that this or any other committee could do is think about how do we make our institutions.
Well, how are you going to do that in the context, though, of one of our leaders for whom I have great respect, going on the steps of the United States Supreme Court, telling two justices if they vote in a way he doesn't like, they will pay the price and reap the whirlwind. And you have another one of your witnesses here tweeting out stuff saying, quote, Some justices are politicians in robes who thrive in a system where access and influence are for sale.
Yeah.
He said they were bought like a sack of potatoes.
Okay, I'm not true. I'm not going to comment on that, Senator. That's not anything I had anything to do with. So
Did I hear the gavel?
I think you
I
did.
hope. Thank you, Senator Kennedy. Senator Hirono? I'm sorry, I got it wrong. Blumenthal, Senator Blumenthal.
Thank you.
Can I say a word before you start? Members are coming and going. We have 2 roll call votes on the floor, so please understand it's not disrespectful. Senator Blumenthal.
Thanks, Chairman Durbin. And thank you to the witnesses for being with us today. You know, as I listen to this exchange, the fact of the matter is the American public want action. The American public is disgusted. They're disgusted with what they see in public life as the degrading of standards and conduct that would never be tolerated in their own workplaces and in their own private lives. And they want us to provide that action. The public confidence in the United States Supreme Court has plummeted. We can go back and forth as to what the cause is, but a lot of the American public are increasingly seeing the justices as politicians in robes. And now, after the revelations about Justice Thomas, as corrupt politicians in robes. They want an investigation. They want the truth. And the ones who are victims here are not only the American public, they're the judges themselves at the lower courts. Year in and year out, federal district court judges, appellate court judges are filling out those forms rigorously, accurately. And now the nation's highest court is seeming to put itself higher than the law. And that is unfair to the other judges who are playing by the rules. And in fact, it is tarring the entire judiciary, undermining that branch of government that has no armies, no police. All it has is its legitimacy. If you undermine that legitimacy, confidence, and trust the American people, there's nothing left of our judiciary. And the greatest democracy in the history of the world, protected by judges who are supposed to be independent and partial, is going to suffer irreparably. That's why I think we need a proper investigation. It should be done by the Department of Justice, because there are allegations of criminal wrongdoing here, violations by Justice Thomas of the disclosure laws, incomplete, inaccurate reporting, as well as non-disclosure. And in the absence of an investigation by the Department of Justice, we have a role to play in Congress. But the judges have a role to play too in protecting themselves. And what Chief Justice Roberts has done in refusing to come before this committee is judicial malpractice. It is a disservice to the courts, to his colleagues who sit there every day, sometimes in danger physically, and always under the microscope of public scrutiny. So I think judges ought to be angry about this crisis of legitimacy that is enveloping the Supreme Court, because it affects our entire judiciary. And I want to ask Judge Fogel, in your experience, although you're a retired judge, my view is judges should be angry and fearful. Do you agree?
Let me answer your question this way, Senator. First of all, I said earlier, and it's true, I have a lot of respect for Chief Justice Roberts. He certainly was a great guy to work with for the 7 years I worked with him. And I think his intentions are good. I think that the rank and file judges to whom you alluded earlier have often felt that they would like the court to be a little bit more robust in asserting itself in this area of ethics and transparency. That it has been not forthcoming in some ways that I think it could be. I'm not saying that there's anything wrong. I'm not here to be partisan. I'm not going to get into that debate. But I think that it would be good for public confidence. It would be very good for public confidence and for the confidence of the judicial rank and file that you were talking about, if the court were more assertive in standing for ethical compliance. And I think this is on the court. I think the court can do it. I think they got some really smart people. I think there are ways that they can do it that don't compromise their decisional independence or their institutional independence. And I think some judges are frustrated that that hasn't happened.
I agree. I've talked to a number of judges who are more than frustrated. They are livid. And I believe their views reflect a growing feeling among the judiciary. All I can say is I urge those judges to stand up and speak out because they can help protect the judiciary as an institution. Thank you, Mr. Chairman.
Thank you, Senator Blumenthal. Senator Cruz.
In 1991, Justice Clarence Thomas appeared before this committee in one of the most disgraceful performances by the Senate Judiciary Committee in our nation's history. Justice Thomas rightly described the treatment he got from then Chairman Joe Biden and Senate Democrats as a, quote, high-tech lynching. It is sad to see 30 years later, this committee is again engaged in the same despicable tactics. Senate Democrats and their lapdogs in the media are engaged in a twofold political campaign. Number one, to delegitimize the Supreme Court of the United States because they are angry that there are a majority of constitutionalists on the court. But number two, very directly, this is a political campaign designed to smear Justice Clarence Thomas. And the reason is simple. The left despises Clarence Thomas. And they do not despise him because he's a conservative. The left despises Clarence Thomas because he is a conservative African American. Here's what Clarence Thomas said at that confirmation hearing. He said, if you are a free-thinking African American, quote, you will be lynched, destroyed, and caricatured by a committee of the U.S. Senate. Well, in 3 decades, that hasn't changed, and it's gotten worse. And to be clear, here's the left's view. I point to one article just 3 weeks ago. The Democrats need to destroy Clarence Thomas's reputation. They'll never successfully impeach him, but so what? Make him a metaphor for every insidious thing the far right has done to this country. That's what the left is trying to do. And I will tell you, if you look at the next poster board, the left has repeatedly attacked Clarence Thomas with a racism. This is a magazine cover that showed Justice Scalia every bit as conservative as Clarence Thomas, but he's portrayed as the master, and Clarence Thomas, in a bigoted attack, is portrayed as shining his shoes. I'll show you another one to give you a sense of the racist vitriol from the left. Here's a racist caricature of Clarence Thomas, lawn jockey for the far right. This is the bigoted contempt the left has. I'll show you another magazine cover. Offensively, this is how the left views Clarence Thomas. Now, it's important for people at home to understand this is not about judicial ethics. You can take those down. This is not about judicial ethics. This is not about rules that should apply to judges across the board. We could have a reasonable discussion about that. This is about applying a double standard to Clarence Thomas and only Clarence Thomas. The attack that my Democrat colleagues breathlessly repeat is that Clarence Thomas stayed at the vacation home of a very close friend of his, a successful Texas businessman, flew on his plane, and went on his yacht. Well, if that's the standard, going and traveling and being paid for by others, then guess what? Just about every Supreme Court justice has done so, and done so in much greater numbers. Justice Thomas was appointed in 1991, and the time since then, he's taken the year later in 1994 took 233 reported trips, including 63 international trips. Again, yes or no, Mr. Payne, do you think Stephen Breyer was corrupt?
No.
Nor do I. I would point out Justice Kagan has done the same thing. Justice Sotomayor has done the same thing. And yet none of my Democrat colleagues care, because this is a political attack directed at a justice they hate. And by the way, let's spend a moment focusing on Justice Stephen Breyer, a delightful human being, someone I know personally, someone who served decades on the court. Justice Stephen Breyer repeatedly traveled on the penny of a prominent Democratic billionaire, the Pritzker family. Now, J.B. Pritzker is the Democrat governor of the state of Illinois, from which our chairman hails. I would be shocked if the chairman of this committee has not had multiple meals with the Pritzker family. Justice Breyer was a longtime member of the board that awarded the Pritzker Architecture Prize. Now, what did that mean? That meant Justice Breyer traveled on the dime of these Democrat billionaires. In 2019, Justice Breyer traveled to New York City, to Vancouver, and Paris. In 2018, Justice Breyer traveled to Ireland and Spain. In 2016, he traveled to New York, Spain, and France. In 2013, he traveled to Norway, Sweden, Denmark. In 2012, he traveled to Beijing and to London. All of this paid for by the Pritzker Foundation. Now, none of my Democrat colleagues are mad about this. And let me be clear. I'm not suggesting Justice Breyer is corrupt. What I'm suggesting is this committee is corrupt, because this is a kangaroo circus. And I will note, we had 15 Senate Democrats, including 6 members of this committee, send a letter to the Appropriations Committee threatening to cut off the funding for security at the Supreme Court. The left is willing to threaten the lives of the justices. Justice Samuel Alito this weekend in the Wall Street Journal said that the attacks directed at the justices are making them targets of assassination. This is disgraceful. Every senator who signed this letter should be embarrassed. Mr. Chairman, I ask unanimous consent that this letter be admitted into the record, and also that the interview with Justice Alito from this weekend be entered into the record. Democrats can have disagreements based on law, but this attempt to delegitimize the court, this attempt to personally smear Clarence Thomas is dishonest, and everyone in the media echoing it is participating in a shameful reprise of 1991's high-tech lynching.
Senator Hirono.
Thank you, Mr. Chairman. We have heard that every other federal judge, members of Congress, and legislative and executive branch employees are all bound by strict ethical rules. But this extends beyond government into the private sector, where employees from the CEO to the sales floor are subject to strict codes of conduct. For example, Home Depot tells all its employees that a conflict occurs when their private interests even appear to interfere with the company's interests, and that the perception of a conflict by others can be just as damaging. Home Depot makes clear that gifts of personal travel for an associate or an associate's family member are never allowed. Ally Bank explains that even gifts from personal friends can appear to be improper if the friendship resulted from a business relationship involving the bank, or the perceived purpose relates to business involving the bank. The bank tells its employees to ask themselves the following questions in evaluating gifts. Does the person or entity frequently provide or offer gifts to me? Is the gift extravagant or otherwise not reasonable and customary? Would I be embarrassed for everyone to know about the gift? Similarly, AutoZone tells all its employees we don't give or accept gifts, meals, entertainment, favors, or anything else of value that may inappropriately influence or appear to influence our judgment. So as we've seen today, the Supreme Court's ethics rules fall far short of the clear binding rules of the executive and legislative branches and those of the private sector. Judge Fogel, these companies have their rules posted online for the world to see. Wouldn't it help restore faith in the Supreme Court if it too had a set of explicit binding ethical rules available for the world to see?
Yes, I completely agree, Senator. I think it would. In the Code of Conduct for United States judges, which all the other federal judges follow, is online. You can find it anytime you want. All of the state courts have something similar that's available online. And I think it's potentially very reassuring to the public, particularly given all of the political back and forth. So yes, I think the answer is yes.
Thank you. Professor Frost, the Supreme Court has a huge impact on the daily lives of every single American. For example, the ruling in Dobbs that overturned Roe has led to chaos in our country over reproductive care. The decision gutting the Voting Rights Act have resulted in over a dozen states enacting laws making it harder and harder to vote. Supreme Court decisions have also sanctioned unlimited corporate spending in elections and diminished the quality of the air we breathe. Professor Frost, shouldn't a group of individuals with such immense power be held to at least the same ethical rules as all other judges?
Yes, I agree.
I want to get to the personal hospitality. That was a huge, I'd say, exception to the disclosure requirements. Before the judicial conference, at Senator Whitehouse's prompting, clarified the personal hospitality exception. The judiciary's rules were anemic at best. If there is even an argument, however unconvincing, that trips valued at hundreds of thousands of dollars might be allowed, it shows how far we are from a strong binding code of ethics. And that is what the Supreme Court needs. And if the court will not adopt one on its own, we must impose one on them. And basically, for all of our panelists, I mean, the highest court in our land should hold itself to the highest ethical standards. And it is so clear that that is not what is happening today. What is so hard for our Supreme Court to adopt a code of ethics? It could have done so 11 years ago, 10 years ago, when our Chairman Frost first brought up the subject. So what is so hard for them to adopt a code that every other court has to abide by? You see, that's what we're facing today. And frankly, I can see why the public has severe questions about the confidence that they have in our Supreme Court, which seems to hold itself above any other court and any of the rest of us in terms of their ethical behavior. Thank you, Mr. Chairman.
Thank you. Thank you, Senator Rono. Senator Booker.
Thank you, Mr. Chairman. Professor Frost, Mr. Dupree, I really enjoyed both of your testimonies, and I thought they were speaking to the importance of trying to find balance. The Supreme Court is probably one of the most important parts of our government, and its independence to rule is critical. And I appreciated Mr. Dupree injecting some skepticism about how anything that we do, if it can be exploited by this very political institution called Congress, is somewhat problematic and something that I would tread on very lightly. And I enjoyed both of your testimonies for that reason. Professor Frost, can I just ask you that there are some legitimate concerns, I think, that Mr. Dupree brought up. And I wonder if you could just talk to me this balance between separation of powers and checks and balances, which you spoke to so eloquently, is really what I'm looking at myself. There's been unsurprisingly a lot of political talk today in this hearing, but at the end of the day, I think America wants their Supreme Court. Something I learned at Yale Law School, if I learned anything, there was this idea of being the appearance of impropriety and how problematic that is for a lawyer, not to mention the highest court in the land. And as was said in some of the early writings, is that the Supreme Court has no army; it vests its power in the consent of the governed. And these are very fundamental ideals. And I'm just wondering if you could help me with that balance.
Yes, and thank you for the question. So I hear Mr. Dupree's concern that we would not want ethics rules to be used as some way in which to penalize justices for their decisions. And in fact, I started my testimony by saying decisional independence is vital. But I actually think it's the absence of ethics rules that is harming the courts and leading to the problems we see today in terms of public perception. If ethics laws were strengthened or passed by this Congress, they would apply to all the justices. If there was more transparency in the court and its process for dealing with ethical problems, then we wouldn't have certain reporters publicizing certain justices' problems. We'd have transparency about each and every justice, whether they were abiding by the rules and what should happen next. So I think it's the absence of laws that is leading to the problem of political attacks on justices. If we had better legislation, we'd see less of that.
And what about concerns you would have when we enter into this space that is not something we regularly do in writing this legislation? What are some of the reasonable concerns that you would have about how that legislation is narrowly tailored to the end that we are looking for?
Well, so first, and I think this is in the proposed legislation, it would be best for the Supreme Court itself to draft a code of conduct for itself. I agree with others on this panel who have said that the code of conduct for the lower courts, which the Supreme Court says it follows or uses as guidance, it maybe needs to be tweaked or changed in various ways to deal with the unique nature of the Supreme Court. So the Supreme Court itself should come up with a code that it drafts for itself, but legislation could tell the court, you must do this now, because we've been waiting since Elena Kagan testified that in 2019, they were seriously considering doing it, and they have yet to take action.
It's almost stunning that they haven't, to me. I don't want to ask you to speculate as to why not. Clearly, America's faith in their court on both sides, people identify as independent, Republican or Democrat, they're losing their faith in this institution. And something that is, I'm an X-generation guy, and maybe like many in my generation, we took for granted the rock solid nature of our democratic ideals and principles until we started seeing them, very unprecedented things happen, including the Capitol being overrun for the second time in American history, not happening before since the War of 1812 and 1814. And so could you maybe at least explain this idea that the Supreme Court, maybe what the founders had in mind in terms of its urgency to self-govern, to do things that would protect itself from that kind of loss of confidence?
Yes, I mean, I think the framers of the Constitution realized how important it was to have a judiciary that was insulated, that its decisions were insulated from political pressure. But equally, the framers realized that they would want Congress to play a role in the establishment of the courts, the lower courts, which are the Congress's choice to create them, and the Supreme Court, which must exist, but does not control most aspects of its administration, like its size, like the quorum requirements, like when it meets. Even significant aspects of its jurisdiction are controlled by Congress as the framers intended. And what they intended to do was have Congress ensure that the courts run effectively to serve the nation's interests. And that's what this legislation
And so the last point I want to make, which is something that, again, in all my studies of the founding of our country, this worry about concentrations of power, this worry about the corruptibility of officials should they not have checks and balances. We have seen that writ large in our society, in the other branches of government, how corruption happens. Because you get elected to the Supreme Court, you are not beyond the corrupting influences of our society, which are often revolving around enormous influences of wealth. And so could you just give me one more point on if we are going to hand on a democracy stronger than we inherited, or at least as secure, is there some wisdom to glean from the understanding the founders had about the fallibility of the people that hold these sacred offices?
Yes, the framers were very clear that there would be partial control of each branch over the other, because no one should be unaccountable, and ambition must counteract ambition, as James Madison put it.
Thank you very much.
Thank you. Thanks, Senator Booker. Senator Hawley.
Thank you very much, Mr. Chairman. Thanks to all of the witnesses for being here. I want to talk about this letter that I think 11 Democrat senators signed, dated March 31st, 2023. It's to members of the Appropriations Committee. I'm just looking here at the signatories. It includes quite a number of members of this committee, as well as others. This is a very interesting letter to me. And I just want to look a little bit at some of the language and what these senators are asking for. They say that Congress ought to impose a code on the Supreme Court. They say Congress has broad authority to compel the Supreme Court to institute reforms. Compel. And then they go on and say Congress's appropriations power is one tool for achieving these changes. Compel. Now, we're going to compel the court. We're going to use the appropriations power. How to do it? Well, they're very specific. Congress should withhold appropriations. Withhold appropriations. And then they go on to say nothing stops Congress from treating the judiciary any differently than any other entity of government when faced with judicial recalcitrance. So here we have judicial recalcitrance. These darn judges won't do what we tell them to do. So we're going to compel them to do what we want, and we're going to use the appropriations power. All right. What appropriations? Well, they ask for $10 million to be withheld. That's an interesting number to me. $10 million. $10 million. Why $10 million? Well, let's have a look at the Supreme Court's 2024 budget request. What do we see? Well, we see $4 million of requests for security funding from the CHIPS Act. $4 million. Then we see an additional $6 million of more security funding that the court is asking for. This is their 2024 budget request. The Supreme Court is asking for $4 million in security funding from one source and another $6 million over and above. 4 plus 6 equals 10. $10 million of security funding that the court is specifically asking for this year in their budget request. And that just happens to be magically the exact same number that my Democrat colleagues want to deny the Supreme Court unless they stop their judicial recalcitrance and submit to the compulsion of this body. So in other words, the threat is we will deny you security unless you do what we want. Let me say that again. We will deny you security unless you do what we want. We had an assassin come to the home of Justice Kavanaugh and try to murder him. We have had credible threats on the lives of other justices. And now members of this body say, we will deny you security for you, your families, your children, unless you do what we want. Extraordinary. Extraordinary. Judge Mukasey, can I just ask you, longtime distinguished jurist, former attorney general of this country, do you think it's appropriate to threaten the security of justices of the United States and their families in order to get them to comply with the wishes of this body?
No.
Have you heard of something like this being done before?
I have not.
I haven't either. And I have to say, at a time when we have had 3 different credible assassination attempts or threats against justices, we still have people illegally going to the justices' homes to attempt to influence their decisions in cases. No one has been prosecuted for those violations. We have constant threats and danger to their children. We had radicals post publicly the school location of one of the justices' children. And in that context, to say that we will deny them millions of dollars in security funding unless they do what this body wants, I think is the height of irresponsibility. And frankly, I can't believe that I'm seeing it. I guess it's just of a piece with what we've seen from the majority leader, who said that, what was it? Schumer, he said Kavanaugh and Gorsuch, that you will reap the whirlwind. Well, I guess we're reaping the whirlwind now, that they're just on their own unless this judicial recalcitrance stops. I hope that we don't have to see another assassination attempt. I hope we don't have to have a justice actually killed before this body will take judicial security seriously and stop its attempts to coerce an independent branch of government. Thank you, Mr. Chairman.
Since the assertion has been stated and repeated here, I want to make it clear that was the Democrats who led the charge to pass the Daniel Anderl Judicial Security and Privacy Act last Congress after the taking of the life of Judge Esther Salas' son at their home. That bill was held up on the Senate floor for nearly 1 year by a Republican senator, unfortunately. The cause of security for our members of the judiciary is bipartisan. Senator Padilla.
Thank you, Mr. Chair. Continuing this important and timely dialogue, as the Supreme Court itself stated in Buckley v. Vallejo, quote, of almost equal concern as the danger of actual quid pro quo arrangements is the impact of the appearance of corruption. End quote. While this case dealt with financial contributions to elected government officials, the same logic applies to appointed judges. There's very serious concern of actual corruption in the absence of strictly enforced, rigorous ethical standards for our judges. But as the Buckley opinion made clear, there's also a serious concern that public trust in our highest court is damaged even by the appearance of impropriety, weakening the faith in our judicial institutions as a whole. Now, what's more, as a former federal judge and advisor to Vice President Mike Pence, speaking of Mike Ludwig here, he said in a statement to this committee, not some far left or whatever tagline some of my Republican colleagues would assign to Mr. Ludwig. He said, quote, this is emphatically not a partisan political issue and must not become one, end quote. And I agree. This is an issue of importance to all Americans. My first question is this, and I'll address it to Professor Frost. Can you explain the effect of when judges take actions that call into question their own ethical standards and how that impacts public faith in the courts?
Yes, it does so in two ways. First, when the law is binding on the justice and the justice does not follow it, I think it both undermines the integrity of the court system and also raises the question of whether the justice is following the law in all the other cases, because of course the justice is responsible for administering the law. And second, you made the point about the appearance of impropriety. So I think it's very important for judges and justices to be aware that even if they are doing nothing personally wrong, they're not trying to be bribed, if they create the appearance of that to others, that is a problem for the legitimacy of the judiciary.
So even the appearance of impropriety can be just as damaging as actual impropriety when it comes to the public trust in our court system.
Yes, and in fact, the code of conduct that applies only to the lower courts, in which the Supreme Court does not have to follow, specifically states that the appearance of impropriety is as much of a problem as actual impropriety.
So speaking of, according to federal statute, all judges are required to recuse themselves when they either have a financial interest in the outcome of a case or where there's otherwise a strong possibility that their decision could be biased. Chief Justice, along with some of today's witnesses, argue that the Supreme Court cannot be subject to sensible, robust recusal rules because the Constitution demands that all 9 sit, and recusal would invite gamesmanship over which justices might hear a case. That's the argument anyway. I'll address this question to Mr. Payne. Is it accurate that 9 justices always make decisions together?
No, sometimes justices recuse and all 9 are not active on a case, but I also will point out the important point that recusal does not necessarily mean that the judge has to get off of a case if you have a procedure where the recusal disclosure, that is the rationale for not recusing, is made public, or the decision to recuse is made public. That also can provide what the public is looking for with transparency.
So I want to bring together the earlier topic in question of actual impropriety versus perceived impropriety, and now the dynamic of recusal. Back to Professor Frost. Bloomberg recently reported that Harlan Crow, the billionaire Republican donor that gave Justice Thomas hundreds of thousands of dollars worth of gifts and travel over 2 decades, had a financial interest in a case appealed to the Supreme Court in 2005, and that there's no indication that Justice Thomas recused himself from that matter. In your opinion, how does a situation such as this, with the absence of recusal, impact the public's faith and trust in the court system?
Yes, again, it's 2 problems. One, there's the possibility, or certainly the public would be reasonable to think that there might be bias when there's a financial interest by a justice in a case that justice is hearing. And second, there's the broader point of it's just disturbing to see any justice not follow a law that applies to them. They're responsible for administering the laws, and they should follow the laws that apply to them.
Thank you very much. Thank you, Mr. Chair.
Senator Welch.
Thank you, Mr. Chairman. We have 2 competing narratives here. We have 5 witnesses and 2 opinions. 3 witnesses believe that it's within the power of Congress to act. 2 witnesses believe it's a violation of separation of powers. We have a dispute here and disagreement among basically Republicans and Democrats about what the motivation is of an ethical investigation, whether it's just a proxy for the competing views about what the outcome of the decisions were. I happen to strongly believe that the court, or pardon me, the Congress does have authority, and I won't rehash that. But I would ask this, wouldn't it simply be wise for the Chief Justice, who is the steward of the public reputation of the court, on his own volition, to adopt a strong code of conduct that the court would adhere to? Attorney General McCasey.
Want a one-word answer? No. Because the strong code of conduct that you hypothesize would then have to be enforced with a mechanism that would involve the questioning of individual justices. He has in his
But let
letter,
me-
he has in his letter to this committee, he has outlined the procedures that are used in cases of recusal.
So let
He
me
has
ask
outlined the
this.
fact that they file the same disclosure reports that other
So if
judges
he had a code
file.
of conduct that included a Supreme Court justice cannot take a bribe, something that they can't do, you would say that would be improper because they would be subject to enforcement outside of the court?
No, I would say that would be redundant because they are subject to the same laws of general application that
I got
apply
it.
to federal
Okay, thank
employees.
you.
They could be prosecuted.
Thank you, Mr.
And they
Payne.
could be impeached.
You have a
That's
view-
not the same question.
Thank you. Do you have a view as to whether it would be prudent for the Chief Justice of the Supreme Court, as the steward of its reputation, to promulgate, or pardon me, I'll ask you, Mr. Dupree, a code of conduct that would apply to all?
I think the Chief Justice, at least Justice Kagan, when she testified before the House several years ago, she said that the Supreme Court was actually considering doing that. They obviously haven't
No,
done
I'm
it yet.
just asking, as a citizen, we have different points of view. But what is the problem with the Supreme Court justice saying, let's have a code of conduct that applies to all of us?
I think the problem, at least the potential problem, would be the one that Judge Mukasey identified, which is to say, what is the enforcement mechanism? Is there going to be some superior tribunal to the Supreme Court that is going to disqualify the
puzzle
justices?
the average Vermonter. But I want to go on to another issue. There's been discussion that there is an agenda here because many on our side disagree with some of the court decisions. Let me just admit, I am one of those who disagrees with a lot of the court decisions. We've talked here about separation of powers, which I agree with, but we've also talked about checks and balances. And my view is that the erosion of support for the court has less to do with the ethical issues and more to do with a public sense that it has completely disregarded the rights of the majority through their elected representatives to pass laws to protect the public interest. Now, I'll ask you again, Attorney General, the Supreme Court has done this before, in my view. The Dred Scott decision, they said African Americans couldn't be citizens. They said Congress could not legislate against slavery in the territories. And historically, do you agree with that decision?
With Dred Scott?
Yes.
Hell no.
Good. But that was the court interfering with the authority of Congress to legislate on what was a majority point of view to start pushing back on slavery.
That was the court making a disastrous
That's correct.
error.
And in the Bruin decision, which was where the New York legislature was attempting to protect its own citizens from the violence of rampant gun violence, the Supreme Court said they didn't have authority to do that. And that is completely divorced from what the majority of American citizens want about gun safety. What say you about that?
What I say about that is that the Bruin decision stands on its own rationale, and it does not have to do with denying anybody's rights or denying anybody's
It denied
protections.
the legislature the right to protect the citizens who elected them.
What it
What
says is-
about
what it
the
says is-
Lochner decision? No, let me ask about the Lochner decision.
Which has been overruled
Beginning of the progressive era. Yeah, it was overruled, thank goodness.
by the
But
Supreme
at the
Court.
beginning of the at the beginning of the progressive era, the court, according to Holmes, who I happen to think was a pretty good justice, and he was a dissenter, said that what was the rationale of the court's decision prohibiting the New York legislature from protecting the workers from working 60 hours a week, that was based on the court's adherence to not a legal principle, but to an economic doctrine of laissez-faire. Do you agree with that decision?
With the dissent or with Lochner?
With the basis of the decision where the court essentially interfered with the legislative capacity to pass laws, in this case, to protect against abusive wage and hour regulations imposed by the employer.
I don't agree with it. And more to the point, the Supreme Court didn't agree with it because they reversed Lochner.
But here's the point here that I want to make, and I appreciate your pushback here. The checks and balances component of the Constitution is being disregarded. The Congress is not autonomous. We are all elected and we reflect different points of view. But this Congress, as in the Lochner Congress, as in the Dred Scott Congress, has the authority and the responsibility to act on behalf of the citizens who elected them and not have that impeded by a Supreme Court unless there's something unconstitutional. The decision-making authority of the court, we're not contesting. I yield back and I apologize for going over my time.
Senator Tillis.
Mr. Chair, I think this is the only day where Senator Welch shouldn't have to apologize. It's his birthday. Happy birthday.
Thank you.
Thank you all for being here. I actually came with some prepared comments to talk about what I thought was covered very well by Senator Graham and Senator Kennedy. So I'm not going to talk about the current state of affairs, but I think that our behaviors and the behaviors of some people in this country have created a really toxic and very dangerous environment for the Supreme Court and the judiciary down the line. And that's what we need to be aware of. We have to stop this here because it won't end here. We'll have protests at district judges' houses. We will have circuit court judges stalked. I mean, we've got a serious challenge here, and I think it's in large part on Congress to de-escalate the situation. But Mr. Dupree and Professor Frost, in you all's opening statements, you looked like you were preparing your opening remarks for a debate on the constitutionality of what we're considering here. And so I'm going to create an ad hoc debate between the two of you and maybe allow others if you want to raise your hand and opine. But you laid out in 5 or 6 minutes a very strong case for saying that any actions we would take here could arguably be unconstitutional. I do think, stipulating to what Professor Frost said in her opening comments, there is clearly a role for Congress to play, and we have in the past with creating the structure for the Article 3 branch that was mandated under the Constitution. But I'm kind of curious about Professor Frost's idea of where the line goes, because I could have read your comments to say that all of the proposals that are before us in the Senate and the House would pass constitutional muster. I think the one that I found most interesting that I'd like your opinion on is the proposal, I don't recall the bill number, that really created the structure where circuit and district courts were really going to be empowered to govern the proceedings of the Supreme Court. Maybe if you're aware of this particular bill, we can go right to your rebuttal, but that seems to be far afield from anything that the founding fathers would have conceived congressional action being appropriate. Would you elaborate that on that for 30 seconds?
Absolutely, Senator, and thank you for the question. The first point is yes. I mean, I think it just is self-evident that you can't constitutionally have a system in which the Congress vests inferior tribunals and our federal judiciary with supervisory authority over the United States Supreme Court. as you know, and as this committee knows, the opening of Article 3 of our Constitution vests the judicial power in one Supreme Court and such lower courts as the Congress may from time to time ordain and establish. And so I think the framers necessarily understood that we have a pyramid. We have one court at the top, we have inferior tribunals below it, and it stands to reason that you cannot vest those inferior tribunals with supervisory authority, including the power to disqualify from a case the Supreme Court justices.
Okay, Professor Frost.
Yes, so if the legislation you're referring to says that the judges on the lower courts will be reviewing the ethical conduct of the justices, that is maybe their financial reporting and not their recusal decisions, I don't see a constitutional problem. The same way there's not a constitutional problem with a justice being prosecuted if they commit a crime like any other judge. So no, the lower courts couldn't review the Supreme Court's decisions for the reasons Mr. Dupre just gave, but they certainly could review their ethical conduct off the bench as a constitutional.
What do you think about the, we're the political body. We were envisioned to be that. And right now they seem to be all doing very well. But it would just seem to me that you'd be creating a framework to where the outside could game it and divide the courts. I mean, suddenly you'd have a group of district court judges who would have one agenda that they would be advancing. You would have others another agenda, and probably some of them not unlike what we have here on any policy matter. But it just seems right for really seeding the field with the politicization of the court. Starts with ethics, but where does it go from there?
Well, I think that's a very serious concern, Senator. I would say in two respects. One is that there's a serious concern that litigants could try to game the system to determine the justices who would be hearing their case. In other words, some of the proposals before the Congress right now would allow third parties to challenge the ability of a justice to participate in a decision. And if that provision were to become law, I promise you, as someone who litigates regularly in the United States Supreme Court, round one of any litigation would be trying to knock out the justices who you think might be opposed to you. That's untenable. Number two, the problem is if you create a system where individuals are incentivized and encouraged to file ethical complaints, I worry that long term that ultimately
It'll be a cottage
corrode
industry. We already have it in other branches of government. It will be a cottage industry. It will be politicized. We will diminish, I think, the integrity of the Article 3 branch as a result. For my part, I think the exchange of information here may be helpful. What I think is more important is that I think that the Supreme Court and clerks are watching this right now. We have heard examples of instances of behavior at either end of the ideological spectrum that was unacceptable behavior. I, for one, hope that this does nothing more than turn into an oversight hearing, not something that lays the groundwork for congressional action, and that the Supreme Court, who rightfully declined with the concurrence of all justices not to come before the committee, that would be a political circus and almost unprecedented in terms of American history to have a hearing of that nature with the Chief Justice. So I just hope, what I care about most is not your confidence in the judicial system, not necessarily the confidence of any one member here, but a confidence of the American people. And I do hope that this process has been instructive to an Article 3 branch who should independently, in the same way that I have an office code of conduct that all my staff have to read and affirm every year. I don't know how many Senate offices have that, probably not many. But I think that they could update, refresh, and address the concerns without requiring any congressional action. And if they act in the near term, maybe this committee could be instructive. Thank you for your time.
Senator Ossoff.
Thank you, Mr. Chairman, and thank you to our panelists for joining the committee today. Judge Fogel, the Judicial Conference has issued a code of conduct which applies to the district and circuit courts, correct? And as I understand it, one of the tenets of that code is that judges should avoid any conduct that can lead even to the appearance of a conflict of interest, correct?
That's correct.
And why is that important?
Because if there's an appearance of a conflict of interest or an appearance of impropriety, then the people who are affected by the decisions that judge or judges make rightly lack confidence in it. They suspect that it's not a fair decision, that there are improper influences.
The appearance of a conflict of interest.
That's correct.
Can undermine public confidence in the integrity of the judiciary, correct?
That's correct.
Judge Mukasey, putting aside the question of how such a code of conduct might be applied to the Supreme Court. And I recognize and acknowledge that there are separation of powers and constitutional concerns that need to be carefully weighed in considering the design of such a system. Do you agree with Judge Fogel that the appearance of a conflict of interest can reasonably undermine public confidence in the impartiality of a judiciary, whether it's a district or a circuit or the Supreme Court?
Of course, so long as you articulate what it is that appears. People often say the appearance of conflict and feel that that's just kind of a nice vague term that they can use to cover a concern about something else. I think if you allege in particular as to a particular Supreme Court justice that there is an appearance of a conflict or an appearance of impropriety, you have some obligation to articulate what it is that appears.
But you agree,
Otherwise-
forgive me, you agree, Judge McCasey, with the principle
Yes.
that as for district and circuit court judges, where they are advised and governed in part by a judicial code of conduct through the judicial conference, that they should avoid any appearance of conflict of interest or impropriety because it can reasonably undermine public confidence in the impartiality of a judiciary, that the public could also reasonably, depending upon the facts, lose confidence in the integrity of the Supreme Court, depending upon the conduct of justices.
Right, and it has to be reasonable. I recall writing on that subject when I was asked to recuse myself because I am a Jew and a Zionist from judging a case involving some terrorists. I refused, and I wrote rather long and elaborately on that topic.
That's right, but you did not, Judge McCasey, and I asked this rhetorically, and I know the answer is no. You did not as a judge or do not as a judge accept foreign travel in the hundreds of thousands of dollars from politically active parties, correct?
From politically active? No, I did not.
Professor, and I think reasonably you might have been concerned that such conduct would have created some public concern about your impartiality and probably would have avoided that conduct even if it weren't strictly illegal for that reason, correct?
I was never offered that conduct because I don't know people who
But that wasn't my question. My question is, as a judge, you quite reasonably and properly would avoid accepting such lavish gifts because of the concern that it could create public doubt in the impartiality of your judgment. Is that
The
right?
only time that I accepted travel and accommodations was from a seminar in economics that I found enormously valuable that was then obliterated because it was said that that created the appearance of conflict.
And Judge McCasey, I'm not in any way questioning or even seeking to interrogate your personal conduct. What I'm asking you is that as a judge, is it fair to say that you most likely would have declined an offer of foreign travel worth hundreds of thousands of dollars because quite reasonably you would have had the concern that public disclosure of such travel could have undermined public confidence in the impartiality of your judgment?
Simply because it amounted to, I mean, if somebody took me, I mean, if I were a district judge and somebody wanted to fly me on his private plane on a vacation with his family and I were friendly with that person, would I have refused and endangered the friendship? I'm not sure that I would have.
Well, I think the American public sees that kind of conduct and quite reasonably asks the question whether it's appropriate. And my impression is that most judges at the district and circuit level, considering the guidance in the Judicial Code of Conduct, Judge Fogel, I don't know if you agree with me, would refrain from such acceptance for that very reason.
Well, I think it's interesting, Senator, the California Code of Conduct, which is very similar to the federal one, there actually is guidance that when you receive social hospitality, you receive a gift like we're talking about here, that you should consider the size of the gift. That's one of the factors you should consider. So that it's one thing if somebody takes you out to dinner, it's another thing if somebody flies you on a private jet to some faraway place. That actually is not in the federal Code of Conduct. I think it is one of the questions, one of the hard ethical questions here is you can focus on whether one's accepting a gift like that should be disclosed, which is something that's under the Ethics in Government Act. And then there's the question of whether the sheer size of the gift creates an appearance. And I think there are different opinions about that. But I think when you're talking about the appearance of impropriety, you need to look at the entire context. And I agree with Judge McCasey that it's what is a reasonable question about whether whether the gift or the hospitality or whatever it is so large that it raises issues of undue influence. I think it's a holistic type of inquiry.
Thank you, Judge Fogel.
Senator Blackburn.
Thank you, Mr. Chairman. Before I begin my questions, I know that a lot of my colleagues have addressed what they see as the hypocrisy of this hearing and the continued effort by our colleagues across the aisle to politicize or smear or delegitimize the Supreme Court. And I find that disappointing, especially when you look at what has transpired in the past year with our justices and the threats, the assassination attempts, the protest outside of their home, simply because people disagree with the decisions that they have reached. And I find it just completely inappropriate. General Mukasey, I want to come to you and talk for a moment about the safety of the justices. And Section 1507, which some of my colleagues have raised today, that section makes it illegal to protest outside of a judge's residence if the intent is to influence that judge's decision making. And we've heard what the protesters outside of the justice homes were saying post the Dobbs decision. Things like, and I'm quoting some of those, "If you take away our choices, we will riot." And another one they would chant was, "No privacy for us, no peace for you." In other words, if the justices were not going to vote their way on Roe v. and Casey, then the protesters were going to keep the harassment up. And as we have heard, they have done that as they have protested Roe v. Wade, as they have protested the Dobbs decision. And despite all of this, the Biden DOJ has refused to enforce Section 1507. And that's why I introduced the Protecting Our Supreme Court Justices Act, which increases the jail time for anyone who tries to influence a judge's decision-making in this manner. And I would just like to ask you, what more can we do to send this message that what they're doing is wrong, to allow these protesters outside of these justices' homes? And you've got justices that I know fear for not only their safety, but the safety of their families. And we've talked about that today. And I do see increasing that jail time from a year to 5 years as one step that we can take, and we should pass that and protect our justices.
Well, increasing the penalty may very well be appropriate, but I think that the key here is there have been no arrests in those cases. None, zero, nada. And to say that that's within the control of the marshals who provide the safety, I think really doesn't pass the laugh test. And to suggest that somehow these people are exercising First Amendment rights when First Amendment rights are subject to place, time, and manner restrictions is really disingenuous. If you had arrests, I'm not entirely sure that increasing the penalty would be necessary, but in any event, let's start with that.
It would be nice to see some people held to account for what they are doing. Does anyone else on the panel have a thought on what ought to be done? Would arrest send the proper message that what they're doing is inappropriate?
I think both
branches frankly have an important role to play in protecting, the brethren, so to speak, on Article 3, the Supreme Court. I think that the executive, as Judge Mukasey said, can play a much more aggressive role in law enforcement, both in protecting the justices, particularly when they're in their homes, particularly when threats are directed at the children of the justices. They can make arrests, and they can just basically take those law enforcement responsibilities seriously. I mean, I think we all can recognize that peaceful protest has an honored role in our society. And, you want to protest on the steps of the Supreme Court, that's one thing. But if you're targeting the justices in their home and their children, I mean, that goes well beyond the line of anything.
And let me
protected.
ask you this then. What about Senator Schumer's threat when you heard it? Of course, we've talked about that some today. Do you see that as an ethical breach of conduct of one branch of government to another?
Well, I think if you have a United States senator, on the steps of the Supreme Court saying what I think most reasonable people interpreted as a threat to individual justices by name if they don't vote a particular way and vote the way that the senator prefers, that they will, inherit the whirlwind or reap the whirlwind or whatever he said, that's obviously not appropriate. I mean, you can't have a system that functions when you have members of the Senate standing on the steps of the Supreme Court threatening the justices in particular cases.
That's right. Three co-equal branches. And that's part of the, I think that is so important to make, Mr. Chairman, that we recognize that. Thank you all.
Thanks, Senator. Mr. Payne, you've asked for a chance to respond, if I understand it, to questions
Yes.
raised earlier.
Yes, just simply clarifying that when Senator Kennedy asked me about tweets that I made, I didn't make the tweets myself. It wasn't my words, but it was pointed out to me that I did retweet a news article that did have additional commentary with that retweet. So I just wanted to clarify that for the record.
Thank you. I also want to clarify that when I had sent the letter of invitation to Chief Justice Roberts, he responded directly to me. The other justices signed on to his ethics statement that was accompanying that response. So they did not technically decline an invitation. It never was offered to them. I said to Senator in my invitation to the Chief Justice, he could come join us, or any member of the court could as well. So point of clarification. I'm going to close this by saying thank you and allowing Senator Whitehouse, if he has anything you want to add at this point.
Thank you. I think what we have here is a situation in which very clear policies and procedures exist in the judicial branch of government and are generally administered through the circuit courts of appeal. And they include very basic things like having a place where a complaint about a judge's ethics can be lodged. The Supreme Court doesn't have that. They include very basic things like having staff people assigned to review any complaints that come in, sort out what makes sense and what doesn't, do the usual filtering that people have to do of complaints that come in. I think every circuit court does that. The Supreme Court does not. Beyond that, once you've done the filtration, if it looks like a complaint has merit, a staff attorney's work with regard to the other federal judges to take a look at the complaint and to do a little bit of a factual investigation so there's a record to decide what's true and what isn't. And that can include asking a question of the judge about what their recollection is of the situation or what their justification is for their position. A factual record gets made. Again, the Supreme Court doesn't do that. I think there's plenty of room, well within even the more extreme views here, to see this as to, forgive me, Mr. Dupre, but I consider these to be non-core duties of the court to comply with these statutes that are permissible to regulate. The court has already agreed to follow and respect and comply with the Judicial Conference rules and procedures. It doesn't seem much to have them also ask, not just comply, but ask, what does it take to comply? And get an answer in advance so they know whether it's complied or not. In fact, that's what the Judge Fogel's Financial Disclosure Committee was set up to do. And to take it another step further, to make the advice that they get, which could perfectly easily be from other judges, it's just advice, public, so that there's a clear contrast between what every other judge has to live by for rules and what the justices arrogate to themselves as the rules that they have to live by. And I'll close by reminding everyone of Ben Franklin's Poor Richard's Almanac, which advised that the best way to show that a crooked stick is crooked is to put a straight stick down next to it. And I think the circuit courts of appeal and the way they behave right now, overseeing the ethical conduct of federal judges, presents that straight stick. Thank you very much, Chairman, for the hearing.
Thanks, Senator Whitehouse. I'm going to close with a personal note. It was my good fortune as a college student to be an intern in the office of a United States Senator named Paul Douglas from Illinois, and he inspired me to aspire to this life. He was, I think, the penultimate leader when it came to questions of ethics and took it to a level that many in elected office in the 1960s wouldn't consider. He never accepted a gift worth more than $2.50. $2.50. And he made an annual disclosure in detail of his net worth and his income tax returns. Very few, if any others, did it. One person did, his disciple, Paul Simon, whom I also worked with for many years. I picked up that tradition of making a complete, detailed income disclosure, net worth disclosure every single year. I don't know that anybody even notices. My wife did for a few years when we had no money, but nobody else really notices that. My goal is to try to make enough disclosure so the questions of my own ethical judgment would at least have to consider that disclosure. I don't know what it takes to restore people's faith in our government, our courts. But this was a good faith hearing on an issue that I raised 11 years ago. It had nothing to do with President Trump. He wasn't the president at the time. Had nothing to do with the agenda of the court today. That was long before that ever happened. I still think this is a valid point. What I hear from the committee today is it's a partisan point. This is now a Democratic cause. I don't think Judge Ludig or Judge Fogel or others, Mr. Tribe, came to this on a political basis. They are looking for a matter of principle, and I still think it's valid. I made my first entree on this issue after the Justice Thomas disclosures with a personal letter, first with phone call, then with a personal letter to the Chief Justice. I respect him. I really think this is his court, and he can make of it what he wishes. And he had a chance to use us if he wanted to. He didn't choose to, or some other means to restore the confidence of the American people, at least partially, in the court. So I hope that regardless of what comes of this matter and these pending matters of legislation, that the court will, in fact, heal itself by the justices leaders, the Chief Justice as leader of the effort. We're going to have a number of statements in the record that will be added with unanimous consent, and there may be some questions coming your way. It's rare, but it happens. And if you receive them, I hope you'll respond quickly. Thanks very much for your patience today. Meeting stands adjourned.
Mr. President.
The senator from Michigan.
Thank you, Mr. President. I have two important things I'd like to speak about today. And let me first start with a confirmation vote we will be having this afternoon on Judge Jonathan J.C. Gray to serve as the U.S. District Judge for the Eastern District of Michigan. Both Senator Peters and I are strong supporters and thank President Biden for nominating him. And we look forward to colleagues joining us in a bipartisan vote, just as we had on the cloture vote, to make sure that he is confirmed today. Senator Peters and I were both honored to introduce him and his family during his hearing in the Judiciary Committee in November. And I know that his family is so very proud of him, as we are. Judge Gray is an outstanding choice to serve the people of Michigan because he's been doing just that. Judge Gray is currently serving as United States Magistrate Judge for the Eastern District of Michigan. As a magistrate judge, Judge Gray has presided over both civil and criminal cases. Before that, he served as an assistant United States attorney in the Eastern District of Michigan and the Southern District of Ohio, where he prosecuted criminal offenses. During the past 10 years, 95% of Judge Gray's practice has been in the federal courts, whether as a magistrate judge or an assistant U.S. attorney. He also worked as an associate at a law firm in Chicago, where he practiced labor and employment law and served as law clerk for 2 federal judges. Given his incredible breadth of experience, it's no surprise that the American Bar Association Standing Committee on the Federal Judiciary unanimously found him to be well qualified for this position. Judge Gray was born in Mississippi and is a proud graduate of Morehouse College and the Georgetown University Law Center. And in the spirit of those 2 institutions, Judge Gray is a deep believer in giving back, both in Michigan and through his alma maters. I can think of no better place for Judge Gray to continue to serve the people of Michigan and our country than on the United States District Court for the Eastern District of Michigan. And both Senator Peters and I urge our colleagues to vote yes to confirm Jonathan Gray this afternoon. Mr. President, as everyone knows, I'm an incredibly proud MSU Spartan. I earned both my undergraduate and my graduate degrees from Michigan State University. And I've been so proud to represent the university in the Michigan legislature, in the US House, and the United States Senate. I'm a Spartan, as is Senator Peters. And I'm horrified and heartbroken, and I'm angry because we're mourning 3 lives that were lost on February 13th when a gunman came to campus and randomly started shooting students. Ariel Anderson, Brian Frazier, Alexandria Verner were each full of hopes and dreams and so much promise. Ariel, age 19, graduated from Grosse Pointe North High School in 2021. She was known for her confidence, her kindness, and her incredible drive. She was studying to become a surgeon. Brian, age 20, graduated from Grosse Pointe South High School, where he competed on the swimming and diving teams. He was studying business, was president of Phi Delta Theta fraternity. And Alexandria, her friends called her Alex, was a 20-year-old graduate of Clawson High School, where she excelled in volleyball, softball, and basketball. She was studying integrated biology and anthropology and had hoped to graduate next year. Ariel, Brian, and Alex had their whole lives ahead of them. And my heart aches for everyone who loved them and is missing them today. We also know that gun violence isn't just about the lives that are ended. It's also about the lives that are forever, forever changed. At Sparrow Hospital in Lansing, Spartans are still fighting just to survive. Thousands more students and employees and community members have been left with scars you can't see, but they're there. They hurt as much and take as much time to heal as anything else. It's crucial that we ensure that everyone receive the mental health care that they need at this time. Last year, my initiative to bring high-quality mental health and addiction services to communities across the country was signed into law in the gun bill that we passed. And right now, it's helping to make a difference in meeting the needs in East Lansing, Lansing, Mid-Michigan community. And I want to thank the Community Mental Health Authority of Clinton, Eaton, and Elam counties for working so closely with Michigan State University right now to provide support for everyone who needs it. So many different things are happening on campus and across the community. Just one example, counselors from Community Mental Health have set up a place in the East Lansing Public Library where they're providing resources and immediate free support from therapists, and people are coming forward to volunteer their time to help make this happen as well. They brought in support animals to comfort those in pain. Clinics like Community Mental Health don't just provide help after a crisis, though. This is about helping people every day, helping people in the first place so that there's a place to call, and there is, and people in the community, family members concerned, people in neighborhoods that are seeing something that they're concerned about need to call and ask for help. But better mental health isn't enough. We also need to make it harder for people who harm others to get their hands on guns, because it's one thing if you are somebody who's unstable and have a knife, it's another thing if you have a gun. The consequences are very different depending on what you're holding in your hand. Firearms are now the leading cause of death for American children and teens. Think about that. Not car accidents, not cancer, guns. We can change that. We must change that. The Michigan legislature is taking action to strengthen our state's licensing process and background checks, require safe storage, and pass a red flag law. What we did last summer was provide dollars to states to develop red flag laws. And I'm so proud of our governor and our new majorities in the State House and Senate for taking action now. I strongly support their efforts. I'm grateful as a citizen, as a mom, as a grandmother whose children are in the schools, that they are taking these actions. On a federal level, last year I was proud to support the Safer Communities Act, which is an important step, but we need to do so much more. We need to pass a military assault weapons ban, legislation that I'm co-sponsoring. And while we're at it, let's close the gun show loophole and ensure that all gun sales in America require a background check. It's just common sense. We owe it to Ariel, Ryan, and Alex, and the whole mental health community, to those who have been impacted across the country. These stories are way too common and should be absolutely unacceptable to everybody. Thoughts and prayers are not enough. It's pretty hollow, Mr. President, as you know, as we've all spoken up about. It's pretty hollow when we are not willing to take the actions that can save lives. And that's the way that we remember those that have been lost. One of the most important things, the most beautiful things about Michigan State and our entire Michigan community is how we came together to support one another. It's amazing. I've been incredibly touched by the stories of how people have helped one another, both on that tragic night and the days since. From the dispatchers and the first responders who immediately and calmly responded to a chaotic and dangerous scene, to the selfless staff at Sparrow Hospital giving comfort and life-saving care every day, to the East Lansing residents and everyone across Michigan who came together and put up yard signs to greet students as they returned to campus. And yes, to the incredible support shown by our rivals. An enormous crowd of University of Michigan students gathered in Ann Arbor on February 15th to show solidarity and support. At the same time, Spartans were gathered at the Rock in East Lansing. A number of Wolverine sports teams have worn special warm-ups honoring Michigan State. And even Ohio State, a great rival as well, hired an airplane to fly above Michigan State's campus, pulling a banner that read, "We are with you, Spartan strong, love Ohio State." The MSU community and the community of East Lansing are so grateful. We are all so grateful for the outpouring of support. We'll get through this, but we shouldn't have to. But we will get through it. We just need to take action to stop this from happening again. We are all Spartan strong. I yield the floor, Mr. President.
Mr. President. The senator from Michigan.
Mr. President, 15 months ago, I spoke here on the Senate floor to commemorate the victims of a shooting at Oxford High School in Oxford, Michigan. And Mr. President, just over 2 weeks ago, as a gunman opened fire at Michigan State University, our state lived through yet another nightmare. Another routine evening turned tragic. Another community was left scarred by unimaginable gun violence. And another 3 families will never see their children come home. Just after 8 p.m. on a crisp Monday evening, gunfire erupted at MSU's Berkey Hall. And as the alerts poured in, students all across campus huddled in fear. Some blockaded their dorm rooms and turned off the lights. Others grabbed whatever objects were nearby and in case they needed to fight back. Parents called their children to check in if they were safe and worried if it could be the last time that they spoke. Those near the gunmen hid under tables and ran for their lives. One student said it sounded like a stampede as they tried to escape. In the end, 3 of their classmates did not make it. 3 students who had their entire lives ahead of them were stripped of their futures in an instant. Ariel Anderson, a 19-year-old from Harper Woods, was a sophomore. She enjoyed roller skating, photography, and live concerts. A committed student, she was working to graduate early and embark on a career as a pediatrician. She had a fierce intellect and a deep love for her family, touching everyone in her life with a kind and gentle spirit. Alex Werner was 20 years old. She was a junior from Clawson and was studying to become a forensic scientist. She was a gifted student athlete in high school, excelling in softball and basketball and volleyball, and a dedicated member of her community. Friends and teachers described her as a leader and a giver, someone who was always smiling. And one of her peers remembered that she was, quote, the very best of us. Brian Frazier, the 20-year-old sophomore from Grosse Pointe, had an infectious smile and a sense of humor that could brighten an entire room. As president of Phi Delta Theta fraternity, he demonstrated a commitment to service and to leadership. He had been studying business and economics when his life was cut short. As a father and a fellow Spartan, my heart breaks for these gifted students, for their families and friends, and the time that was stolen from them. My heart breaks for those who survived, who will carry the weight of this horrific memory for years to come. And while this scene unfolded, first responders and law enforcement officials bravely leaped into action. Dedicated doctors and nurses have worked around the clock to help the 5 students who were critically injured. And I'm grateful to these men and women for their tireless work. At the same time, I know that the students and staff at MSU and the broader East Lansing community will need time. They will need time to heal in the wake of this tragedy. But they shouldn't have to do that work alone. We can honor them by taking meaningful action, and we must do that now. Last year, Congress showed that common sense reform is still possible with the passage of the bipartisan Safer Communities Act, the most significant legislation to address gun violence in nearly 3 decades. It invests in mental health resources, expands school safety measures, enhances background checks, and includes new guidelines to make sure we keep guns from getting into the wrong hands. And while it's clear that this law did not go far enough, it has begun to make critical changes. We are already starting to see its benefits reach my state. Last week, Senator Stabenow and I welcomed $8 million in federal funding to the Michigan State Police. This investment will help combat drug violence and enhance crisis intervention programs all across the state of Michigan. But there's so much more that we can and we must do. We must pass legislation to expand federal background checks to all gun sales, a measure that I helped to reintroduce here in the Senate and one that is supported by the overwhelming majority of the American people. We can enact reasonable limits on high-capacity magazines and close dangerous loopholes. We can pass red flag laws while still respecting the rights of law-abiding, responsible gun owners. And we can invest in first responders like those who so bravely answered the call at Michigan State. The choice is ours to make. We can honor these young adults by making change, or we can play politics and let this cycle continue. But for Ariel, Alex, and Brian, and for the students and staff at Michigan State, and for every family that has been torn apart by gun violence, we must choose to act. Madam President, I yield the floor.
Thank you, Mr. President. Mr. President, the Senate in quorum call.
We are not.
Mr. President, if you ask any Republican what kind of energy policy he or she supports, you'll likely hear the phrase, "and all of the above energy policy." And today I want to take a minute to talk about, first, what we mean by an all of the above energy policy, and second, why we support this kind of policy. So, Mr. President, what is an all of the above energy policy? Well, as the name suggests, an all of the above energy policy is an energy policy that embraces the full spectrum of available energy resources, both renewable and conventional. It's important not to ignore the conventional part, as many of my colleagues across the aisle would like to do. It's not enough to embrace renewable energy, even multiple types of renewables. And for reasons I'm going to discuss, any energy policy that doesn't embrace conventional as well as renewable sources of energy is insufficient and places both our energy security and energy affordability in jeopardy. But back to my explanation. As I said, an all of the above energy policy is an energy policy that embraces the full spectrum of available energy sources. It embraces wind, solar, hydropower, biofuels, biomass, geothermal, nuclear, oil and natural gas, and more. That's the definition, Mr. President. Now, why is an all of the above energy policy important? Why not, for example, eliminate fossil fuels from the mix? Or why not choose one or two renewable fuels and put all our energies into advancing those one or two technologies to hasten the arrival of a clean energy future? Well, there are a number of reasons why these options or those options, and any option that doesn't embrace the full range of available energy technologies, are a bad idea. First of all, the fact of the matter is that we are simply not yet at the point where we can rely solely on clean energy technologies. We will still need conventional energy.
Security conditions permit. Again, we are certainly gravely concerned. Go ahead.
Thanks, Doreen. Does President Biden have any reaction to CIA Director William Burns meeting with Jeffrey Epstein in 2014? This obviously was after Epstein had served time for a sex crime and was registered as a sex offender.
I'm just not going to comment on that from here.
Okay. And can you also, how does, President Biden says that he's the most pro-union president in history. How do you square that with the fact that he is not openly offering support to the striking writers?
Because it's an ongoing strike, and you've heard us say many times before, we don't speak to an ongoing strike, but more broadly, and I said this yesterday, President Biden is a strong supporter of workers' rights to strike. We've said this over and over again as we've been asked when different entities, and you see workers strike in those different entities. We've been very clear. He has worked to bolster workers' rights, including through appointing a strong leadership team at the NLRB and through his efforts to advance the PRO Act. Again, we encourage both sides to stay at the table, but we are always very mindful.
Why can't he speak about an ongoing strike?
I mean, look, this is something that we've done continuously now. This is nothing new that has been said from this podium, but this is a president who strongly supports workers' right to strike. We've said that over and over and over again. You see that in his record. This is someone who supports labor unions. Again, this is all you have to do is look at his record as a senator, look at his record as a vice president, and certainly as a record of as president. Go ahead, Mike.
Thanks, Green. I want to follow up on the question of the timing of this invitation, because as recently as Friday and into the weekend, officials here in this building had been saying there were no plans to invite Speaker McCarthy. It felt like a rather abrupt shift then to this Big Four invitation going out Monday. Was the White House caught off guard at all by the timing of the new X date as it's known, which seemed to be earlier than even some analysts had been forecasting?
So look, we knew Secretary Yellen's letter would be released yesterday, and the president thought it was a good opportunity to remind congressional leaders of the urgency of preventing default. So we were aware of the letter. The timing is up to the Department of Treasury. That is something for them to decide. But again, the president thought it would be a good opportunity, again, to remind congressional leaders that we must not default. It is their constitutional duty. Congress must act, and that is something that we've been very, very clear about and very repetitive about, as you know, from here.
In 2011, Vice President Biden had to delay a foreign trip because he was, at the time, involved in the debt ceiling negotiations as well. We saw President Obama also had to postpone a foreign trip during another fiscal showdown with Republicans. The president is scheduled to travel a very long way for quite a bit of time during this month. Is there any even notional discussion in the building of curtailing that trip?
So I don't have any changes to share to his schedule or anything to announce at this time. The president, as you know, Mike, is president wherever he is, and the economy, as it relates to the American economy, that is always a priority, a top priority for him. Don't have anything else to share, but it is their constitutional duty, Congress's constitutional duty, to take action.
Would you delegate somebody like the vice president to step in to handle some of these in-person negotiations while he's traveling abroad?
Look, don't have any changes to announce. I get your question. We still believe very strongly it is Congress's duty to act. It is their constitutional duty to do just that, and I'll just leave it there.
Quickly on another matter, yesterday there was an announcement related to vaccine requirements, testing requirements that will no longer be in effect, tied to the end of the public health emergency on May 11th. Can you update us on some of the protocols here in the White House? Is there any change that might, especially for staff who interact with the president, as it relates to those?
So as we said yesterday when we made the announcement, we'll have more details to share about these requirements in the upcoming days. nothing at this time new or ahead of the May 11th kind of changes that you'll see, that we're going to see. I'm going to go to the back, and then I'll come back down.
Thanks, Green. Given Senator Feinstein's critical vote and any chance of passing a clean debt limit hike, as the president has said he would like, is he concerned about her prolonged absence further hindering Democrats in the Senate now that it's getting to the budget?
Look, we wish the senator a speedy recovery. I don't have anything else to share beyond that. I talked about the close relationship that he has had with Senator Feinstein and the work that they've done over the years, not just with him as a president, but also when he was a senator. He appreciates her, thinks that she has, has really helped change a lot of important critical policies to the American people. I don't have anything to say specifically about when she's coming back or what that looks like, but we certainly wish her a speedy recovery.
Just one more. Last week, the president signed an executive order authorizing the use of the National Guard at the southern border in support of counter-narcotics efforts. Can you explain, was that a precursor to today's announcement on the troops?
I'm not gonna get into the timeline of it. As you know, we've been making preparations ahead of the lifting of Title 42. We've been very clear about that. You've heard from the Department of State, DHS as well, on what they had a press conference to lay out what that's going to look like. So there's been many processes and plans that have been put into place. Don't have any specifics to any timeline that you're asking. Okay, I'm trying to call somebody. I have it. Go ahead, Christine.
Thank you, Colleen. If the president's priority is to treat the immigrants humanely, like you said, wouldn't he be sending social workers, psychologists, judges, lawyers to the border instead of sending active military personnel?
So look, I want to be clear, the active military, as I just explained to one of your colleagues here, it's been done for more than almost 2 decades now. It is a personnel that's performing administrative tasks and like data entry and warehouse support. That's what they're going to do, so they can help free up the CBP, the Border Patrol agents, to perform some critical law enforcement duties. And so that is their function. That's what the active duty is going to do. They're not going to interact with migrants. Look, yes, we would love to be able to have more resources at the border to do the critical work that is needed. But the reason why we're moving in this direction, and of course my DoD colleagues will speak more on this, is because Congress has not acted. As you know, Christina, this is something that the president has taken very seriously, putting forth a comprehensive immigration reform legislation on his first day to deal with DACA, to deal with migrants, to make sure that we fix the system, make it more modernized, right? Do it in a humane way. That is something that the president wants to do. But we are using the tools that we have in front of us in our tool belt to deal with what we're seeing currently at the border. But of course, yes, we would love to have more resources at the border for sure.
Thank you so much. First of all, on Sudan, we've just seen news that the combatant leaders have declared a 7-day ceasefire and that they're open to talks. First of all, just the White House reaction to this, and does the White House or does the U.S. government anticipate having a role in these talks? What are your objectives? And are you going to use this time, these 7 days, to either get in humanitarian supplies or get out American citizens?
So look, I have not seen those reports, so want to be super mindful. But look, we remain in close contact with the Sudanese military and civilian leaders to see what we can to help them identify a path to reach a sustainable cessation, of hostilities that include humanitarian arrangements. And we are engaged at the highest levels regularly. I had said this yesterday. I'll say this again. The president's the senior level of the president's national security team has been in direct contact with SAF and RSF leadership, and we have called to continue the ceasefire. We have called to bring down, to stop what we've been seeing, the violence there. We've been doing that for the past week and being very vocal on that. But again, there are conversations happening. We'll continue those conversations from the highest levels here to SAF and RSF leadership, and that's what we're going to continue to do at the president's direction.
Looking ahead to the G7, we've seen reports that the president's going to sign an EO limiting some American investment in key sectors of China's economy. Does he plan to sign that before the G7, and what's the thinking behind that?
So we'll have more to share on what the agenda, what the trip is going to look like. I don't have anything to confirm at this time. Bless you. Phil.
Bless you.
Was it you? Who was it? Oh, I'm so sorry. Here, I'm calling you out, and it wasn't even you. Gesundheit, bless you.
Allergies are bad this year.
Oh my gosh, the pollen is quite something.
Thank you for the question. So Governor Greg Abbott has said that he will continue sending migrants to Democrat-run cities after Title 42 expires. The mayors of Chicago and New York have already responded saying they simply do not have space. What is the administration doing to help state and local governments prepare ahead of the expected influx of migrants?
So look, it's unfortunate that Governor Abbott continues to play politics with migrants and with the American people, because what he's doing, that's what it looks like. It looks like a political stunt instead of trying to address the situation, or maybe get the congressional members and senators that are in his state to actually ask them to work with us on truly dealing with a problem, with trying to figure out how do we deal with immigration reform. Instead of doing that, he wants to play politics. So that's what we've seen from this governor. It's not surprising. That's what he's continued to do. Our administration has been in touch with mayors and local government to see how we can be helpful to them. That has continued over the last several months because Republicans continue to play politics here, to put political stunts ahead of actually making change. And if you think about what we put together, if you think about wanting us to protect, put protections for dreamers and farm workers, more immigration judges and asylum officers, more funding for border security, and all of this, which is part of the president's legislation, and what we've been urging Congress to act on. What we saw just earlier this week is over 430 business groups wrote to members of Congress calling on them to get this done. 430 businesses have called on Congress to get this done. So this is getting support out there. American people want to see this. Businesses want us to act as well, want Congress to act. And so we're going to continue to do that and to call on Congress, but Republicans are in the way, and Republicans in Congress are getting in the way. And what Abbott is doing does not help the situation.
I hear what you're saying about immigration reform. I'm not hearing specifics about how you're providing resources to state and local governments to handle the expected influx.
And I have said that we have been in touch with state and local governments to help them in any way that we can. We have done that this past several months, whether it is Chicago, whether it's New York City. We have had extensive conversations, even with the DC mayor, on how we can help moving forward. And again, we're in constant communication, whether it's the White House, whether it's DHS, whether it's FEMA even, and how we can help cities. Every city has their own specific need that they need to address to this issue. And so, yeah, we've been in constant communication. That has happened. And I've talked about it multiple times, whichever mayor is asking for assistance from the federal government.
Just quickly on the meeting on May 9th, is that purely a scheduling decision? Given the urgency of the situation, why wait a week before meeting with the leaders?
Well, look, as you know, Speaker McCarthy is out of the country currently, and I have no idea when he's coming back, but he's out of the country, so that clearly has pushed this meeting a little further down a couple of days, and we want to make sure we had all four of them here. As for who's attending, no one has asked me that yet, but I know people are probably curious who's attending. I would certainly ask their respective offices to see if they've accepted the president's offer. But again, this is we want to make sure all four of them were able to make it, and the president's looking forward to hosting them here and having a real important conversation about our American economy and how we're going to move forward for the American people.
I wonder if the president would support a short-term extension to the debt limit so that conversations about budget and debt limit can continue potentially to September or for any other period of time.
What I can tell you is the president believes that it is Congress's duty to get this done. It is their duty to make sure that we move forward with dealing with the debt ceiling. But certainly, we're not going to negotiate in public. And our position is going to be very clear that Congress needs to avoid a default. And I'll leave it there without conditions.
Is extension on the table at all?
We won't negotiate in public on any of this. What we will be very clear about is that it is, and our position hasn't changed, right? Congress needs to avoid a default.
And just one more question. Speaker McCarthy reaffirmed commitment to Ukraine yesterday to continue to send aid. Did the president have a response to that at all? Did he know that he was going to make that commitment?
So, look, we're glad to hear that Speaker McCarthy agrees it is vital to keep supporting Ukraine. It was good to hear him push back on the propaganda put forth by Russian state news outlets, as we have seen over the past year. President Biden has rallied the world to support the people of Ukraine as they defend their territory against Russian aggression. The widespread bipartisan support that we've seen in Congress for Ukraine has been critical to those efforts, and we agree that it is important for that support to continue, and we're glad to hear that coming from Speaker McCarthy for sure.
Thanks, Corinne. I wanted to ask about the trial going on in Arkansas with Hunter Biden and the child support. Are the president and First Lady monitoring that? And how come they haven't acknowledged the seventh grandchild?
I'm not going to speak to that from here. Go ahead.
What is happening with the COVID-19 task force after May 11th with Dr. Job depart? What about remaining staff?
So we'll have more to share on that in the upcoming weeks.
Thank you. If the border is secure, as the administration has said, then why would we need to send 1,500 active duty U.S. troops down there?
Because we need more work. More work needs to be done, Peter. We put forth a comprehensive immigration legislation, and Congress, Republicans in Congress refuse to act. And so the president has used the tools that he has in front of him to prepare ahead of Title 42 lifting. As you know, that is happening in the next couple of days. And so we are putting DHS, Department of State, is putting forth processes to deal with the changes that are going to be ahead of us. And so that is what's important here, and that's what you've been seeing for the past several months. You've heard from DHS, you've heard from the State Department on what we're putting in place to deal with the border once Title 42 lifts.
You said yesterday that when it comes to illegal migration, you've seen it come down by more than 90%. Where did that number come from?
I was
CBP
speaking.
is telling us the number is.
I hear you. I'm about to answer.
136,000 people more.
I'm about to answer you. If the dramatics could come down just a little bit. If the dramatics could come down a little bit.
What's dramatic about asking a question about?
Okay, I'm going to answer. So I was speaking to the parolee program. As you know, the president put in place a parolee program to deal with certain countries on ways that we can limit illegal migration, and we have seen the data has shown us that it has gone down by more than 90%. That was what I was speaking to. No, we're gonna go. We're gonna move. Go ahead. We're moving, Peter. Let's go.
Just two quick follow-ups on the meeting next week.
I'm not sure who's speaking.
Sorry.
Yeah. Yeah. Go ahead.
One more on the vaccine mandate being lifted on May 11th. Do you guys plan to rehire anyone who was fired or voluntarily resigned under that policy? Would they get any sort of compensation, back pay, anything like that?
We'll have more to share, more details to share in the upcoming days on requirements. Don't have anything new to share on that at the time.
On the debt ceiling, you talked about this is Congress's duty, we're not a deadbeat nation, all that kind of stuff. But what's the president's plan to convince McCarthy of this? What do you plan to do to get him over to your side and convince him to see things that way?
Well, the question is to Speaker McCarthy. What has changed? The question to Speaker McCarthy is, in the last administration, he voted three times to deal with the debt ceiling. So the question is to him, what's changed under this administration? Okay, we're going to keep going. Go ahead.
Still on the debt ceiling, if I can just zoom out. Ultimately, what is the president's priority? Is it to avoid this thing of linking debt ceilings from now forever to budget negotiations, which he doesn't want? Or is it to avoid a debt default? Because I know he wants both things, but what's his ultimate priority? Because like in a game of chicken, at some point, you can wait for the car, you can wait for the car, you might have to jump out the way.
So look, and I said this earlier, the president thought it would be a good opportunity to remind congressional leaders of the urgency of preventing default when the Secretary Yellen's letter came out. So that is incredibly important. We cannot default as a country. We cannot. It is not good for the American people. It will hurt taxpayers. It will hurt veterans. It will hurt seniors. We're talking about 6 million jobs here. We cannot allow that to happen. The president is going to continue to fight and speak out about that. And we're going to be very clear. Congress needs to act. Congress needs to act. So that, of course, is going to be a priority of that conversation. It is going to be important for the president to make clear to Speaker McCarthy and also to MAGA Republicans, as we have been for the past several months. We've been very clear. The president said yesterday, we are not a deadbeat nation. And what's different here? What is different here? They were able to do it with Democrats and Republicans were able to do it in the last administration. So what's different here?
Playing chicken analogy, you might not have a choice to think about this too much at some point. If the proverbial car is like, about a couple of inches away, he's got to dive out the way. Does that mean he accepts what they say and avoids the fault? If it comes down to that.
The question is for Congress. It really is. What has changed? Why were they able to do this 3 times? Why were Republicans willing to come together with Democrats 3 times to deal with something that is their constitutional duty? That's the question for them. Really, guys, it's the question for them. They were able to do this again 3 times. And now under this administration, they refuse to do it. Let's not forget what we're talking about. This is debt. More than 90% of that debt came before the president came into office.
Okay, go ahead. Thank you, Corinne. Can you explain the decision a little bit on why you decided to invite all 4 congressional leaders to this meeting instead of just Speaker McCarthy? The standoff has largely been between the president and the House Speaker. So do you all now see a role for the Senate, possibly a leading role in them getting this debt ceiling
Look,
resolved?
the president thought it'd be important to get the 4 leaders here to talk about incredible, critical issue, right? Which is how we're going to move our economy forward. He wanted to have the 4 leaders here. This is certainly a continuation of conversations that happened in February. And so I wouldn't read too much into it. He wants to bring them here, have a conversation, important conversation that is critical to the American people, critical to American families. And that's how I would view this meeting.
And today, House Democrats began the groundwork to try and force a vote on the debt limit and go around McCarthy through a discharge petition. Was this idea brought up during the president's call during these?
That's something for House Republicans to speak to and Speaker McCarthy to speak to. I'm just not going to speak to the mechanics of what's happening on the other side of Pennsylvania. Again, I know I tried to call on you.
Two quick just follow-ups. So given what you said about Congress's role in the debt limit, has it been the position of the White House that there is no legal alternative to congressional action? There's nothing else that could be done to raise or suspend the debt limit or prevent a default in any way absent action from Congress?
Do you mean legal action from us?
There's no executive order or any sort of executive action that could be taken either through the Treasury or the president to avoid a default.
So again, I'm going to sound like a broken record as I have been for the past several months. Congress must act. We will not entertain scenarios where Congress compromises the full faith and credit of the United States.
So that means that the administration does not believe there's any power it has.
Republicans and Democrats have prevented default 78 times since 1960, including 3 times, as I've mentioned, over and over in this specific briefing under Trump. And so they have to do that again. So that's where I'm going to leave that for you.
One more, if I may, and apologies if you sort of answered it in an earlier question, but is the administration playing any role at all in the WGA strike negotiations?
No. All right. Thanks, everybody. I'll see you tomorrow.
Live in the swamp, but
August here is really
unnecessarily painful. Okay, we good? All right, good morning. My name's Ana Lilia Mejia. I am co-ED for the Center for Popular Democracy, and we are here today because sadly, extremist dark money groups have captured our courts. And truth be told, everyone here is completely terrified, as you should be. Harlan Crow, a Texas real estate mogul, has applied his wealth in ways which any reasonable American can see is meant to influence and control. It is but the most recent example, however, of the type of unethical behavior that has destroyed the public's confidence in the highest court of the land. Dark money groups like the Federalist Society have created a 40-year strategy to control the Supreme Court. And apparently, through Justice Thomas, they are succeeding. In the past year, justices have thrown out nearly 40 years of precedent to overturn Roe v. Wade. They have weakened protections for workers. They have decimated protections for voters and struck down common sense gun safety laws. Our federal courts depend on the public's confidence for their very legitimacy, and they are in trouble. Americans should have faith that their Supreme Court will protect their rights, and yet we don't. Americans should believe in their courts, and yet we can't. We deserve sitting justices who are the embodiment of our highest ethical standards, and they are not. What we demand today is for action. Doing absolutely nothing to change the status quo will not protect the court from any claim that it has been politicized. The deed is done. The court is politicized. This is a huge problem that needs a huge and immediate solution. We must bring transparency and accountability to the Supreme Court. We must restore faith in our justice system. And we must hold the Supreme Court accountable, because as a critical part of this three-legged stool of our government, it is imperative that it function with transparency, ethical behavior, and morality. So today we are joined by many leaders across our nation who are focused on ensuring equity and justice across our government. I am proud to introduce our first speaker, or second, Mr. Rakeem Brooks. He is the president of the Alliance for Justice and is a friend and partner to CPD, as well as to every conscientious American. Let me introduce Rakeem. Thank you.
Good morning, all. Again, my name is Rakeem Brooks, and I'm president of Alliance for Justice and AFJ Action. I don't want us to forget why we are here today and what prompted these hearings. Yes, we need ethics reform. Absolutely. Alliance for Justice has been calling for a code of ethics for over a decade, along with many of my colleagues. As many have said, the highest court in the land should not have the lowest ethical standards. All of the justices were previously bound by a code of ethics at some point in their careers. It makes sense that they should be bound by a code of ethics now. But in some ways, this is bigger than that. Without any changes to the law, we can say without equivocating that Justice Thomas has transgressed. He has defied our most basic understandings of public service. He has broken the law and our trust, so he must resign. Take a moment to think about how you felt when you first read the ProPublica article. Just think back to it for a moment. Hundreds of thousands of dollars, yachts, jets, and none of it publicly disclosed. It's unbelievable. We've never heard anything like it about any member of the court. It's unprecedented and it is wrong. We all know it. Justice Thomas knows it. That's why he took the time to respond. Chief Justice Robert knows it, and that's why he's ducking the calls to testify. Congress and the American people know it too, and that's why we're having these hearings today. You cannot reap extreme profit from your public service. We don't need a code of ethics to tell us so. We know it in our bones. It requires no explanation, no expert analysis. When you become a public servant, we all agree that you will forsake riches while in office. You may indeed be friends with millionaires and billionaires, but you don't get to share their world to build a mansion in yours. You cannot use your seat on our Supreme Court to live like a rich, rich man beyond the reach of modesty or public reporting. But that's exactly what Justice Thomas has done, and so he must resign. He may think it unfair to be held to such a standard. Politicians court wealthy donors at fundraisers all the time, and I'm sure we'll have a press conference about that at another point. But why can't he? Here's why. Because the justices protect the flame of liberty. The whole of who we are resides in their judgments. That is why Alexander Hamilton said, "The complete independence of the judiciary is peculiarly essential in a limited government." He and the founders, flawed as they were, understood that all of this, our entire democracy.
¿Lo hicimos? No, tú lo hiciste. Lo hice. Puedes hacerlo.
En AutoZone.
Of gun violence. It begins now.
Maybe we should hide it.
Hi.
I put
Yeah.
mine down on the floor.
Hi, everyone. We're about to start. Find your seats. Thank you all for coming. A couple quick announcements that you've probably heard in other sessions already, but if you have cell phones, please silence them now. We are live on C-SPAN, and we want to make sure that there are no interruptions. And the other sort of most important thing is to know is that all of these guys will be signing their books afterwards, and there will be people who can direct you to the signing area where you can purchase their books and talk with them more. So welcome, thanks for coming. My name is Miriam Powell. I'm a writer and journalist. I write about California history and farm workers and not about guns. So this was actually a treat for me to be able to read these books and learn so much about an incredibly timely topic. I'm going to do quick introductions and then we'll get right into the conversation, and we will have, we'll leave some time for questions and answers at the end, and there'll be microphones for that at the appropriate time. So to my left is Mark Fullman, who is the National Affairs Editor at Mother Jones and the author of Trigger Points: Inside the Mission to Stop Mass Shootings in America. Moving to the left, we have Jennifer Carlson, who is an Associate Professor of Sociology, Government, and Public Policy at the University of Arizona. She is an expert in gun culture. This is her second book on that topic, and she is a 2022 MacArthur Fellow, right? And finally, we have Ryan Bussey, who is the author of Gunfight: My Battle Against the Industry That Radicalized America. He has a fascinating personal story. He was one of the top executives at a gun manufacturing company and took on the industry first from inside and now from the outside. So people who come at this very timely issue from a variety of points of view, insiders and outsiders, and I think we'll have a lively conversation. So Ryan, I want to start with you, and we want to try to sort of put this issue in a little context, and I'm going to throw out key dates for each of you, and the first date is 1994, and that is when President Clinton signed the assault weapon ban. And you write a lot about this as it being a very important inflection point in terms of the National Rifle Association and the transformation of that into an organization that you have now spent a lot of time fighting against. So take us back to 1994. What happened, and why has that become so important in the trajectory of this topic?
Yeah, thanks for having me. I've struggled, like a lot of other people have, to try to understand how it is we went from a childhood like I had, hunting and shooting with my brother and grandfather and father on a ranch, and a responsibility around guns, to where we are today. I think we've all struggled to understand how our politics got from where they were 25 years ago or 30 years ago to where they are today. And what I realized is, through the writing of my book and through my life in the industry, the trajectories of both of those questions, actually, they are the same graph. And I look at the sort of genesis of that, to Miriam's question, I look at the genesis of that as being 1994. That's the year the assault weapons ban passed. You should know the assault weapons ban did not ban all AR-15s. You could still buy lots of AR-15s. What it did is ban semi-automatic rifles with an additional list of features. It's a bit arcane and troublesome, but it didn't just ban all guns. What it did is set our modern politics and gun situation and divisiveness and us versus them and existential battles and all that stuff. It set it on its course. The NRA lost that vote barely. They fought a policy battle. They didn't fight a culture war over it. All the former presidents at that time lobbied for it, including Ronald Reagan, who wrote a letter of support for the assault weapons ban. And it passed barely. And as I note in my book, it's my experience that the NRA learned a lesson from that they would never again forget. They would never not vilify the opponent. They would never not raise it to a culture war. They would never not create us versus them, zero-sum game, existential battles. And they didn't, and here we are.
Talk a little bit more about what you saw in the transformation of the NRA during that period, and how it turned into a force of evil.
Well, there's been a lot of writing about the NRA, and I think from afar, the NRA looks like this finely honed, scientific, unbelievably clever machine. I didn't experience it that way. It was more of a bumbling kind of operation that stumbled into basic core truths about humans and human interaction and how fear can motivate people. And about then, they figured out, and certainly 5 years later, really after Columbine, they figured out, after we now know, thank you to enterprising reporters like Tim Mack from the NPR, who found the tapes from this. But basically, they decided, are we going to be a constructive part of society and negotiate and do the hard work with democracy, basically, like operate in the gray area, not in the polls, but in the gray area. They tried that in the assault weapons ban, and in their mind, they got their ass kicked. Come 1999 and Columbine, 5 years later, they had a choice again, and they literally thought about this. They decided it. They debated it. We know, we've heard the tapes, and they essentially said, should we do this? Should we, it looks bad. We got dead kids. Should we be a part of society and try to craft a solution? Or wait a second, could we use this to spin up a conspiratorial, fear-based system and tell people that they're going to lose their guns over this? And might this drive political outcomes? And might that also drive gun sales eventually? Let's give it a shot. And here we are.
Great. And now, Mark, I want to take us to 2012, because you've done work for now more than a decade, really. But is trying to prevent these assaults from happening to begin with.
Yeah, well, first, also thank you to the LA Times Book Festival for having me at this terrific event. It's great to see so many people just here who love books. That's wonderful for any author. So 2012, I had done some reporting on gun violence prior to that, but that, of course, was a watershed year specifically for the problem of mass shootings. Sandy Hook was, at one time, an unthinkable event. Unfortunately, that's no longer the case. And when that happened, I was already very well familiar with the very entrenched political dogfight that we have in our country about this issue. Anyone who's followed it knows it goes way back. I mean, the political trajectory that Ryan was describing 2 decades prior, and you can see the straight through line from there to where we are today. And of course, the attack in Aurora too, which, you know, by today's standard, in its own right, I mean, it sounds a little weird to say this, may not seem shocking, but then it was a truly shocking event in terms of its scope, that someone would walk into a movie theater and injure and kill that many people. And I was really struck by that and started specifically investigating questions about mass shootings. And I was very startled to discover that there was really no public data on this problem, which is why we set about building the database at Mother Jones, to just start gathering information to answer some basic questions. Who's doing this? Is it happening more frequently? What weapons are they using? What is their motivation? And importantly, were there warning signs, which was something I had started to see very early on in this research. And that's really what led me to the subject of prevention and the field of behavioral threat assessment, which is the focus of trigger points. Really, for me, fundamentally, the question I got really interested in that year amid all that horror and devastation was, what more can we do about this problem? Because even then it was already escalating. And if you think about the decades since, it's just remarkable how much we've seen this problem grow and evolve in some very, very troubling ways. So I became really interested in kind of pushing past the political debate in any way that I could find. It's an important debate. Gun control is a very important debate, gun regulation, our gun culture. But of course, we've been having a lot of the same arguments over and over for many years. And when I started to learn about this prevention method and started to get to know some of the people who were pioneering it and leading it, and handling cases that were really successfully stopping people from committing this kind of violence, I became very interested in knowing more, and that led to the story of the book.
Okay, Jennifer, we're going to now skip to March 2020, which, you know, I think I read, and we all sort of probably read about the surge in gun buying at that point then, but it was really startling to me to see the numbers in your book and in Ryan's. And in March 2020, when COVID shut down everything, there were 5 of the 10 highest days ever recorded of gun sales, right? And more guns were sold that month, I think, than any month in history, correct? So how does that, how does that lead to your book directly? And how does that, in a more general context, change the debate and the nature of the conversation about gun violence and gun culture?
Yeah, so I should start by saying I'm a sociologist. And so what that means is I study society, I study meaning, I study culture, I study what everyday people do. And about 13 years ago, maybe a little bit more, you know, I was a graduate student at UC Berkeley, and I was trying to figure out what to write my dissertation on. And this was right around the time that, you know, gun sales were flying off the shelf because Obama had just been elected. And I thought surely, you know, sociologists who are armed with these tools to understand society would want to understand something so profound and pervasive within American society, which would be, of course, the question of people not just owning guns, but also carrying guns. And I was quite surprised to see that there was basically nothing. There was very little in terms of sociologists wanting to ask this kind of question. And so that's actually where my first book comes from, which is Citizen Protectors, which is about the everyday politics of guns. So not the top-down NRA story, not the story of gun violence, but the story of why people are, mostly men, not just owning, but also carrying guns. And so, you know, my work has really been focused on this everyday politics, and I had a very different project plan for 2020. I thought I was going to be doing very different kinds of research, and I think we all felt, you know, the world closing in on us, things were getting shut down, it's March 2020, and I think, how am I possibly going to be useful at this moment? And then I start seeing the headlines of gun sales surging, and, you know, unlike the surges that happened in the 90s, surges that happened, you know, when Obama's elected, there's a saying in the gun industry that Obama was the greatest gun salesman in American history because of just the surge. Of course, that was followed by the Trump slump, where sales actually plummeted, and so this sudden increase in gun sales in 2020 was actually quite strange also, because there was no mass shooting. There was no high profile instance of gun violence, which is another, kind of way in which panic buying in the gun world is kind of routinized. And so, yeah, basically I was like, all right, this is what I've been trained to do. And so I started calling up gun sellers and asking them what is going on in your store. And what I found was, of course, the headline, which is that gun sales were surging. And it wasn't just your kind of stereotypical, the profile of the white conservative married man. I think that's from the South or the Midwest. But that actually there was first-time gun buyers, women, racialized minorities, sexualized minorities, and even liberals who are buying guns. And so this is a story that I try to tell in the book is really, how do we make sense of this moment where even gun sellers at some points were like, they realize that they can't shoot a virus. I mean, I think this was kind of a joke outside of yeah. And it's funny because I think a lot of people who were watching this, who were not embedded in gun culture was like, doesn't make sense. The gun sellers themselves were also scratching their heads, at least at the beginning. And so there's this really interesting moment that I try and get at in the book where, nobody actually really knows what's going on. Nobody can make heads or tails of this. And I think at that moment, that's something that tells us something very profound. It's going to become very partisan, but at this moment of chaos and uncertainty, that this is what Americans turn to. They turn to firearms. And I think that, that didn't happen in most other countries. Most other countries had a stronger social safety net. They had a sense of cohesion and solidarity. It happened, actually, Brazil was, I think, one of the only other countries that saw a similar surge in gun purchasing. And so I think it gets at this way in which guns have occupied this central role as tools of safety, security in this country, where, as we've seen, as 2020 unfolded and into 2021, our social safety net, our political system is frayed, to put it mildly. So I'll end there.
Come back on a little bit on the subject and what you touched on about the different types of people who were buying guns in 2020, and then also George Floyd, and how does that tie in, and in what ways does that the difference in the people who are buying guns change potentially the debates about gun culture?
Yeah, there's a lot there. So in the book, I try to talk about 2020 as a multi-layered crisis. I feel like that's one of those sociological phrases that is very cumbersome, but there's really no other way to talk about it because you have, a world-changing pandemic, you have the rise of defund the police, Black Lives Matter, you have racial unrest, and then you have democratic instability and everything that, culminated in January 6th. And so, it was very interesting talking to gun sellers over this period. So I interviewed them across this period. And, at the beginning, it was very, it just wasn't clear. Nobody really knew how to fit what was happening into sort of the narratives that we have, right? And so as that sort of unfolded and we get to the murder of George Floyd, things start getting more familiar, and things start getting more familiar in terms of, the arguments about the police are not going to be there to protect you. The only thing you can rely on is yourself. There was some really interesting, conversations I had with gun sellers who were like, yeah, I'm seeing more African-Americans in my store, and none of them like Black Lives Matter either. They're not supporters of that. And so it was very interesting. And I talk about this in the book that, there was a lot of, enthusiasm for the demographic diversity that gun sellers were seeing in their stores, but it was also framed and, in terms of these very particular ways of imagining politics and how politics should be done. So, not engaging the sort of collective politics that has historically characterized Black social movements in this country, but emphasizing individual rights, the individual as the, individual rights and individual sovereignty as the source of democratic engagement and freedom and all of those sorts of things. So it was really interesting. They were very enthusiastic about the wide range of people that were coming into their stores. Of course, the buck sort of stopped when it came to liberals. And that's when, the conversation about, they're going to be irresponsible. I have to make sure that they're safe gun handlers. They might do more harm than good. And I think that really this is, this question of how porous gun culture is. And so, yeah, it was really interesting to see how those conversations developed over the years.
Mark and then Ryan, do you guys want to jump in on the 2020 phenomenon and the surge and how that affected what you wrote about?
Well, I was still in the firearms industry, 2020. It was, and I'd been through a lot. I got into the firearms industry in 1995. I left in July of 2020, and 2020 was like unlike anything I'd ever seen. Bear in mind here, prior to Barack Obama leading in the polls in 2016 or in 2008, 2007, 2008, the United States had never consumed more than about 6.5 million new guns in a single year, not once. By the time Barack Obama left office, the United States was consuming almost 17 million guns. So that's why President Obama, despite all the attacks on him, was called, as Jennifer said, nobody referred to him in the industry as President Obama. They call him the best gun salesman in America for that reason. But by the time 2020 rolled around and you had this conflagration, you had all the stuff that Jennifer talked about and lockdowns and then Kyle Rittenhouse and then an election and a stolen, all this stuff, 23 million guns that year. So we go from less than 7 in 2007 and 8 to 23 million in 2020. In the last 3 years, we put about 56.5 million new guns in the general public. We now have about 415 million guns in the United States. To give you an idea what that is, drive around LA. I did this morning. Looks like there's lots of cars. There's 267 million registered vehicles in the United States. There's 415 million guns, 150 million more guns than there are cars. So gives you an idea of the scale. And 2020 was just, unbelievable, off the charts. Now it did start, like Jennifer said, in the firearms industry. There was all kinds of, oh my gosh, the demographics spread out. It's, we've been wanting this forever. Now everybody's buying them. By the end of 2020, it was back to the same kind of cadre and reasons and fear and hatred that it was driving it.
Yeah, and I would just add, specifically in the context of mass shootings, there was kind of an interesting question in 2020 because there seemed to be a lull. There weren't any major high-profile attacks for a number of months, maybe almost a year. And this provoked some interesting theories about why that was related to the pandemic. I've, to this day, not seen any kind of scientific conclusion about why there was that kind of brief pause. But I would say that, it was pretty clear to me pretty quickly in terms of what was happening politically, both a continuation of what we'd seen in our national politics during the Trump presidency, but then also what was happening with COVID and the further kind of polarization that was happening around that and themes of grievance and political rage. I knew, I think, in a fundamental way that this pause was going to be temporary. And of course it was. And not only that, but there are more mass shootings driven by political ideology now than there were. It's something that's gone on historically, but it is an increasing phenomenon, primarily coming from the far right, not exclusively. But this is a significant evolution of the problem too, with targeted gun violence rampages in public places, with that in the mix.
And how did it change the commitment to what you focus on in trigger points, which is behavioral threat assessment? I mean, was there more focus on it because of the increase in the mass shootings and in the high profile nature of them?
Yeah, certainly leaders in the field of threat assessment who I was speaking with around that time were really expressing very stark concern about the political dynamics in the United States and what that could lead to, and we're essentially confirming that extreme ideology as a factor in mass shootings was something more on their radar, a higher level of concern. One of the things I write about in the book, though, is that no single thing is predictive of a mass shooting. It's actually a very complicated equation, often in terms of the question of motive. Why do people commit attacks like that? That was something that I was fundamentally interested in from the very beginning, and what really drew me to the subject of trigger points, because it is a field of work that is bringing together collaborative expertise to try to answer that question. And it can be very difficult in a lot of cases. There are cases where it's really almost impossible to say what the motive was. But what was so fascinating to me about this prevention work is that really it developed around the idea of studying the patterns of behavior and circumstances that lead up to these attacks, which are planned attacks. These are planned acts of violence. And we have some big myths about mass shootings that persist even now. I think there's been some improvement in the public discourse and in media coverage, but the notion of mass shooters all being totally insane and unhinged and snapping, we used to hear that nonstop after mass shootings. That's not the case. That's not what happens. These are people who are planning, in many cases, for a long time, very carefully what they're going to do. So that also is the opportunity of this prevention work, because there are patterns of behavior and circumstances that are detectable and identifiable in ways that can work towards intervention. Political ideology then began to figure in more to that.
Right,
So.
right. So Jennifer and Ryan, I want to ask you, you've read each other's books. Can you comment on what did you learn, Ryan, what did you learn from Jennifer's book? Was there anything that surprised you? Were there things that validated? What was your response reading her book?
So I got an advanced copy of Jennifer's book. I remember I was, after I read it, I was hiking with my dogs up above our house. I remember it very clearly on a conversation. And I was quite excited because so much of what she writes about, I've felt for such a long time that the American public would be interested in this. And we were just talking about it before the panel started, about the inner workings and the sort of critical nature of the gun business, gun resellers, how important that is to the right, how much information and sort of social science travels through that conduit, how integral it is to the far right movement. I contend that without this sort of social glue that guns and gun sellers provide, the sort of far right would crumble or sag. And when I just felt quite validated in that opinion and was really interested when I read her book.
And Jennifer, you on Ryan?
Yeah, I mean, I would say that, one thing, if you basically consume any media on any side of this debate, you are going to be just overwhelmed by polarization, right? You're going to be overwhelmed by standpoints that say this is what it is, and just completely put the other side out of mind. And that's not really, in terms of what people in the US actually think about guns, that's not actually very accurate. And it's also extremely problematic to have a debate about something that is so profound and complicated and has such high stakes when you have this sort of contrived two sides. And so I would say that the thing that I appreciated most about Ryan's book is actually just the sheer premise of the book, that you're coming from, inside the firearms industry with an honest, open standpoint on what this means beyond your paycheck, right? And so I think that's just really powerful. And I see this, and the thing that I want to point out is anytime someone does this in this debate, they get ripped apart by both sides of this debate. And it's pretty terrible. It's a pretty great illustration of the toxic culture that we have right now. But I think, I would say, anytime you see someone doing that, even if you're like, I don't know if I totally am on board with this middle ground that's being, that's being traversed, I would say, pause and try and sit with it a little bit, because that is the way that is one of the things that we need to move forward if we are going to have a debate where we can even sit in the same room and have a conversation. So.
All three of you come from background. Two of you grew up with guns, and Jennifer, you grew up in what you describe as a conservative environment and place, and you talk about your father. So you're not, all of you are in some ways not what the stereotypical, protagonists to take on the gun industry. And so I want each of you to talk a little bit personally. Jennifer, start with you because you write about this, I think, very movingly, sort of in what way this book was an attempt to bridge those gaps and the way in which your own personal story figured into that.
Yeah, Yeah. I mean, I would definitely not characterize my book as anything related to, on the scale of trying to take on the gun industry as much as trying to have a conversation or incite a conversation about where we are in terms of partisanship. So I don't know if anybody got to see Laura Dern and Diane Ladd yesterday, a beautiful mother and daughter story. You can buy their book. And it was just really profound because their book is just premised on conversations that they had, um, 3 years after his diagnosis, passed away, which was in June of 2019. And so I think in some ways, there's the kind of story of I was kind of at this point where I had the tools to do this research, and so I jumped in. But the other very personal motivation in writing this book is really to ask this question of what would my conservative, West Point, University of Chicago MBA, I write all about it. He is the quintessential conservative. What would he have done? Where would he have been in this? And so, I think it's important, I think especially with like just how toxic and intense partisanship is, I think the more that we can open ourselves up to vulnerability and open ourselves up to not having everything be so clear cut. This is the first book I've written where I've let it be more of a question in the end, rather than, this is a sociologist with a, clear cut, nice, analysis and a nice little bow. And I think that kind of openness, I think, is what is what we need. So yeah. So Father was definitely in this in this book.
And Mark, you were a national political reporter before you, and you still are, but you've really devoted so much time to guns. What brought you to that?
Yeah, well, I would say I tried, dare I say, to be apolitical with this book, which is maybe next to impossible on the issue of guns and gun violence. But I think just I contextualized this very briefly at the opening of the book, talking about growing up in the Midwest, and I guess I felt thankful for that background and experience in that understanding the kind of more mixed politics of that part of the country, gun culture. I grew up shooting riflery at summer camp, trap shooting. It was a very different culture then, as Ryan was describing, in terms of, the NRA was about safety and responsibility. And I remember that vividly from, the summer camp years. But I wanted to get past the politics. That to me was the big challenge in a way of writing this book, and to think about, how else we can kind of frame or reframe this problem, because we're just so stuck in the same heated arguments politically, and the way that that's weaponized politically to maintain the status quo. I think, the dynamic that Jennifer's describing, there are people in power in the gun lobby, in the gun industry, and in political office who are very invested in keeping it as it is, to have the same arguments over and over, because it's very profitable, both politically and financially. For me, in trying to answer the question, what else can we do? What more can we do about this? What I realized in doing the work of research and reporting that went into the book for years was discovering that, there are ways that we can really kind of demystify the problem of mass shootings, because that's really come up with the politics over and over again. The othering of mass shooters as these insane, evil monsters that we can't possibly understand. And then everyone just goes to their corners again with the same gun arguments. For me, it was, well, let's understand the nature of this crime. Who's doing this and how and why? And it turns out that the answers to those questions are very different than what we hear about often in the political debate. Probably the single greatest example of that, one of I think the biggest and most damaging myths we have relates to mental illness. The way that